Welcome to Looking at Legal Stuff. Today we have part 2 of an 8-part minor guardianship case consisting of 16 hearings, including 2 trials, the second of which is 4 days long. At the start of this case, the paternal grandparents already have physical custody of the child because Dad left his daughter with them after they kicked him out of their house for not taking care of her or following their rules. But this was not a court-ordered guardianship, so when Dad showed up at their house after 6 months of no contact and wanted the child back, his parents panicked and filed for a full legal guardianship. Dad is fighting this guardianship tooth and nail, claiming he's finally ready to be a good parent. The guardians claim that they've never kept their son from seeing his daughter, and they want him to take care of her, but they also want to make sure that he has the skills and resources necessary to do that first. They claim that Dad has always been a lazy and neglectful parent who has pushed off the care of his child onto the women in his life, and they're extremely worried about just handing the child back over to him, because Dad, who is 23, currently lives with his 52-year-old girlfriend and her sex offender son, who isn't supposed to be around children. Are Dad's claims that he has a plan to keep the child safe and healthy going to convince a judge? Let's find out. This full case will be broken into 8 different 3-hour videos, so make sure you watch all 8 parts to see the full story.
Good morning. We're here on the minor guardianship docket for May 16th. I'm Commissioner Dave Nelson. And it looks like our first case will be guardianship of Jalen Sloan. I see Mr. Ludwig, Ms. Crate, Ms. Farr, Ms. Winkles, Mr. Anagnostou, and I don't, on the iPhone, can you identify yourself? All right, you're not identified.
Just spoke with my client and I know he was going to be here, so.
Was he going to call in or video in?
I believe he calls in.
All right.
And Your Honor, I'm not sure what's going on with my camera. This is the second time I look like I have this light in my face. If the court doesn't mind, I turn off my camera just because it's a little off-putting.
That's fine. Is Jaden Ludwig here? All right, I'm not hearing from him, but Mr. Anagnostou, you can represent his interests. Following the hearing a week or so ago, I asked for this hearing to discuss expanded visitation. My initial thought was, could we consider overnights? I received a declaration of Ty Ludwig, which I read, expressing some concerns about that and making an alternate proposal. So I guess I'd like to go around and hear from everybody on that issue. Why don't we start with Mr. Anagnostou, and then I'll go to Mr. Ludwig, and then after that I'll go to Ms. Winkles. And then if either Mr. Ludwig or Kelly Crate wish to respond, and then finally I'll go to Ms. Farr and hear everybody's views on that. So Mr. Anagnostou, go ahead.
Yes, Your Honor. We notified counsel of the overnight weekends that we want, and that would be not this weekend, but next weekend for an overnight, and then Father's Day weekend in June before we come back to court. And we got a response back, basically ignoring the request, and then we get this declaration on Monday, which is basically a motion to reconsider. In the interim, my client has completed a parenting class. We emailed that to you today. He got the certificate to me late yesterday, and we got it to you, Your Honor, this morning. So I've read Mr. Ludwig's declaration. And basically what he's saying is, if you're a working parent, you don't get custody of your child. That's what he's saying. That's just obscene in these cases. He works. He and Kelly Crape, they work long hours every day. And Jalen is in daycare. So my client works during the week, and Jalen will be in daycare with my client's grandmother. And then when he gets off work, he will be with Jalen. But none of that matters for your determination right now, because right now what we're trying to do is get overnights going. You indicated that one of the visits each month could be overnights. We've notified them of the dates that we want. And we get this declaration in response saying working fathers don't get custody of their children. It's wrong. It goes against your decision. It's a motion to reconsider. It's, the same arguments that we've been hearing that my client can't parent his child. Well, he hasn't been given the opportunity. He needs to have overnights with his daughter. He needs custody returned to his daughter. He's going to get custody of his daughter, and we need to get this process moving. And they don't want it moving. And this is just another example of them stalling and delaying and doing everything they can to prevent the inevitable, which is my guy's a good father, and he needs custody of his daughter. So we would ask Your Honor to acknowledge or support or make certain your ruling from the trial at the end of trial that my client gets one overnight a week. We've notified him of which overnights during the week, one overnight during his weekends. We've notified them of the weekends that he wants overnights, one this month, one next month per your ruling. And then he's supposed to have one visit where it's just him alone. He's going to do that. He's going to get that set up. And then he has the other regular visits that you've already ordered. I'm not sure why we're arguing over this yet again, other than they don't want the inevitable to happen, which is moving forward with Jalen being returned to my client.
Counsel, I don't think I ordered overnight visits. I wanted this hearing in order to consider them. And so I think I want to clear that up. I was thinking out loud as to when they could be, but I don't think I entered that order. Let me ask you, if I do order overnight visits, where would your client go with Jalen for the overnight?
My understanding was what you were considering is that they would occur locally here. And I assume, and I think my client has had a conversation with the petitioners, that they would not be object to him taking Jalen to Portland, to the zoo, or to some, play centers or whatever in Portland. So there's no restriction that he has to stay in the state of Washington, but maybe, not more than 100 miles from Longview.
All right, thank you. Ms. Winkles?
Yes, Your Honor. My clients have no intention of keeping this child from the father. What they want is a phased-in approach. This is a man that's essentially never been alone with this child. At every single visitation, he's had a third party present there, essentially performing the parenting functions. This is a man who couldn't be honest with where he lived, who works next to Michelle Harrington, which is hours away from where grandma lives. Yet states that he lives at grandma's house, which makes no sense of how he could arrive at work. We have that issue. We also have the issue of the fact that he's been not forthcoming about the fact that he lives with a registered sex offender who was convicted of rape of a minor under the age of 12. These are huge issues. But on top of all that, we have somebody who has never parented a child alone. And so now what we're asking him to do is to essentially have a supervisor there. That was part of what Your Honor was thinking out loud. That's not the intention of these visits. The intention of these visits is to form a bond with the child. If he's working all day and then he gets this very, very young child, the child's going to inevitably go to sleep early. That's not going to be bonding time. So really, who's going to be doing the parenting functions? If we go to grandma's house, it's going to be grandma. Grandma's going to do it while he's at work, and grandma's going to do it at night. This is not what the court had in mind. What my clients think is more appropriate would be to extend the visitation by 2 hours and then move up to 3 and move up to 5 and keep moving up. And in that expanded visitation, that the father has to be alone. That way we have a safety protocol in place. The child it's a daytime visit. If there's an issue, he can return the child early, which he's done on a number of occasions. He has continually returned this child early, or not shown up. But in any event, there's a safety protocol in place, and that's the guardian. We give him that expanded visitation so that he can kind of try out being the primary parent, the only parent in charge of this child. Then eventually go to overnights once we have that. But right now, what we're essentially saying is you can have the child for your normal daytime visitation, but we're also going to give you the child at night. But there has to be somebody there. So there's somebody essentially performing these parenting functions still, because you're not going to be on your own. You're not going to be showing the court anything. And I understand father has a certificate for a 4-hour online parenting course, which is great. It's a step, but it doesn't mean that you've actually taken an in-person parenting class. It doesn't mean it's a 12-week class like Children in Between or anything of that nature. It's a 4-hour parenting class through what appears to be some offset of the University of Florida. This child needs to be protected since dad has yet to show that. The child comes home wet in clothing. The child was never changed. We've heard testimony about all that in the beginning part of the trial. We've seen declarations from people stating that dad's own dad can't take care of himself and has to have these third parties there. That's not the bonding time that this is supposed to be, to have somebody else taking care of the child. While my client says that Michelle Harrington, they're fine with her, that doesn't mean that delegating that parental function to her. These parties aren't married. Mr. Ludwig and Ms. Harrington aren't married. They're not in a CIR. They're not in anything of that nature. So to just delegate to another third party is essentially just moving the minor guardianship to somebody else, and that doesn't make sense. What makes sense is a phased-in approach where the child is with dad longer, and we'll try it. And if dad does a great job, great. Then we move on to overnights. But let's make sure this child is protected in the interim, in the short period of time. And again, I just want to stress the fact that dad did not disclose that he was living with a registered sex offender and has not fully disclosed where he actually lives in comparison to where he works every day shows that this is not somebody we can take on the honor system of, you will not take this child to that house. That honor system right there is broken. And additionally, the fact is that he first told the GAL that he was going to live there with the child. That is not in the child's best interest, obviously, to live a sexual offender for rape of a child under 12. We need somebody that makes good decisions for the child, which is why the emergency guardianship is in place right now. This is not hopefully forever, but it needs to be phased in, and going directly to overnights when dad has never been alone with the child. It is scary. It's problematic. The safety mechanisms aren't in place. And if they are in place, it means really that a third party is parenting this child. So my clients would ask that we don't go immediately to overnights. We do 2 hours, extend that even more. We could do 4 hours, extend that, but dad has to parent the child alone during that extended visitation. Thank you.
All right, thank you, Ms. Winkles. I'm actually going to change the way we're going to go here. I'm going to go to Ms. Farr next, and then I'll give Mr. Ludwig and Ms. Craig the chance to speak if they want to. Ms. Farr.
Good morning, Your Honor. So one of the problems for me, and I brought it up at the last hearing, is that I have had no communication with father. I did say at the last hearing that going forward, I needed more cooperation. I still haven't heard from him. I haven't heard from him since mid-January. I sent him an email in April asking him to give me some updates. He hasn't responded. He hasn't called me. I have no way to know what improvements he made, what changes he's made, where we're going without him communicating with me. I did receive the certificate of parenting class this morning, which is great. I'm glad that he completed that class. It would have been better had he reached out to me to let me know that he was doing that, so we could have discussed what he learned. There's no way for me to make recommendations to go forward and expand the current visitation schedule without communication and follow-up from father.
All right, thank you. Mr. Ludwig, anything you'd like to contribute?
Yes, Your Honor.
Okay, I'll let you go ahead. And we'll
Sorry.
Go ahead,
Right.
Mr. Jaden Ludwig.
Okay, Your Honor, the reasons why I bring a third party isn't to take care of my kid. I take care of my kid up there. I do all the work. The reason why I only have a third party is because I do not feel safe around Kai. I do not feel safe around Kelly. Kai used to physically abuse me. He used to pick me up, poke me against the wall. I don't
Your
trust
Honor,
him.
I'm going to object.
You
It's
know,
not properly before the court, and
Actually,
there's no declarations about this. It's essentially testimony that
All
has no
right,
relevance.
we're having arguments, so I'm going to overrule. Go ahead, Mr. Ludwig.
I sent that information in. It should be
You don't have to explain what the information is. Just go forward.
okay. I just don't feel safe around him.
Yeah.
Kelly's manipulative. I lived with them for most of my childhood. I know how they act toward how they felt and how they was treated me. So I just don't feel safe around them. That's the only reason why I bring a third there. That is it. Not to take care of my kid, not to parent my kid, not to do any of that, just for my safety. Because Kelly abused me, hit me, scratched me, kicked me for the last court case that I had dealt with her. So I just personally do not feel safe. That is the only reason.
Is there any reason why you're not in touch with Ms. Farr, the guardian?
I've been working. I work from 7 a.m. to 3:30. Some days I get off at 2:30, but majority of it is 3:30. And I come home, I take a shower because I sweat, I work outside, I work with tires, I'm filthy. If I don't clean myself, then I should be, dirtier than this. I worked yesterday. I, took a shower, got cleaned up. It was hot. It was about 85 degrees here. So I was sweating. So cleaned off. I take care of myself and I take care of Jalen. I think I should have overnight visits is because right now I only have 5 hours from 1 to 5 right now. And then on Sundays I get 11 to 5. And I feel like if I have overnight visits and for having overnight visits, it's for me it feels better it gives me a chance to bathe Jalen, to feed Jalen dinner, to provide for her. I do everything else like as a parent, as a father should.
Where would you do the overnight visits?
I would do the overnight visits in Longview, Washington, over at the Red Lion Motel. That way, it has a shower. She has a bed. She will have clothing. She's a warm place to stay. She'll be right beside 2 beds. Boom, boom. So she'd be right there, should be supervised by me as her father, as one father should. And I just feel like if you guys give me the opportunity to show, even share your thought, if you'd like to come on that overnight visit over for a day over that overnight, one of those on that overnight visit and see what I'm doing, then that will be fine. It's just, I haven't been able to contact her.
Okay. All right. Thank you. Kai Ludwig, do you want to add anything?
I got some concerns on the overnight visit. I think things so far have been going well enough. But like I think that baby steps need to be involved on this. And that's pretty much all I got to say on that is I think we're ready.
Ms. Craig?
Yes. Can you hear me all right, Your Honor?
I can, yes.
Okay. So a couple things I want to bring to the attention. I have never in my life abused a child. I actually work in early childhood education as a director to multiple centers. I have a associate's in early childhood education. I have never been accused of abuse. And if Jaden felt this way and is scared of me because of the way we've treated him in the past years that he says, why would he leave his child in my care in the first place? That just would show lack in judgment on his part. Second, I have been very, very, very understanding about letting Jaden make up visits. He missed a visit because his car broke down this weekend. I offered to let him make it up next weekend. Not a problem. If he wants her for longer hours, I've offered that. He has not taken me up on that. And then two court sessions ago, we brought up the fact that Jalen was not getting naps, and you said that he had to be sensitive to it. She's still not getting naps. The only time she's napping is when she's exhausted in his car ride on the way home from whatever event they've been at. He has not successfully even been able to nap her during the day yet. So these are my concerns, that he's still not. It's easy to come and take a 3-year-old to the park and to the bounce house and to go swimming and be this fun, happy thing. But it's a whole nother story when you have to start actually parenting that child.
Mr. Jaden Ludwig, we've heard from you, so I think we need to move on from that. Mr. Anagnosta, though, I'll let you have the final word.
The final word is that we need to move this along, my client has an appropriate plan, and we're talking about weekends up here, not where she's going to be living in the future. If you want me to go over that yet again, Your Honor, we'll tell you yet again that he's going to relocate back to his grandmother's house with Jalen in Toledo, Oregon. He'll commute to work or he'll find other employment, but Jalen is in daycare currently. And I don't understand why she can't be in daycare with his grandmother when he has custody, but that's all for a later date. Right now, we're talking about moving this case along. We think getting overnights is crucial to show that to continue the relationship with my client and his daughter. And it's within all of the bounds that the court's going to set. It's up here. And he'll be doing the care of Jalen, and they can complain about her coming back in wet clothes or not, or whatever. That's all past issues that we dispute. But we need to move this forward. We need to move it forward. He needs to get overnights up here. One of his weekends would be overnights. We're asking for not this weekend, but the next weekend, and then Father's Day weekend. And then we understand your suggestion, and if you want to make it an order that one of the weekends he's got to come up here by himself, he will do that. He is very uncomfortable doing that, but for a day visit, he'll come up and try to get an exchange without some kind of dispute erupting between him and the Leadwood seniors, who, they don't have a good relationship, and he's concerned about not having a witness, but he's going to follow your honor's orders, and we'll do those visits where it's him alone, and then he has his other visits. So we ask that your honor go ahead and order the overnights as we're requesting.
Your Honor, I would just like to say one thing
Sure.
about the communication with Father. It's been 5 months since I've heard from him. I haven't had any updates at all. I didn't know he had a new job. I didn't know he did the parenting classes. I don't know anything because he hasn't communicated with me. A half-hour phone call or even a 15-minute phone call, I don't think is too much to expect, especially when I have been complaining and requesting that we have that communication. In the past, since this case has been going on, I have done my best to work around his work schedule, done early morning or later in the day. I think we even did a weekend once. So those excuses don't make any sense to me, that he has to come home at 3:30 and take a shower and then he doesn't have time to call me. That's an hour and a half. You still have plenty of time to arrange a phone call. So, I recognize from what I hear in these hearings that Father is making some progress. But I don't have any information that is relayed directly to me from him that I can follow up on to give any recommendation to expand visits right now.
All right, thank you. So at the hearing on the Friday that we had, it was also clear to me that the father was progressing with Jalen, which I thought was good. And I raised the question of whether we could consider overnight visits. After hearing the arguments today, my decision is that we're not ready for overnight visits at this time. We are ready for expanded visitation if it can work out. But let me tell you some of the issues on the overnight visits. First of all, I did ask the father to be sensitive to the need for Jalen to nap, and that has not occurred, and that's a concern to me. That is a need to be sensitive to the needs of his daughter, and I was hoping that nudge would mean that at least for an hour, maybe hour and a half during their visits, that would occur. Apparently that did not occur. I'm also concerned about the communication with Ms. Farr. It's been a long time. It's extremely important for me that the parties communicate with the guardian ad litem to help them form an opinion that will assist me. And it just, if there's no time during the day to communicate with Ms. Farr, that it just creates concerns for the court. I know Mr. Ludwig has to drive a long ways. I would like to begin on Saturday. Apparently his visitation is 11 to 5. I'd like to expand that so it starts earlier and ends around 6 for the purpose of allowing them to have dinner together before Jalen has to be returned. But what I don't know is how long transportation takes and whether sometime before 11 is realistic. Mr. Jaden Ludwood, do you have a sense of when you could start those visits?
Yeah, Your Honor, as soon as possible.
Well, okay, well, you have to drive a ways, don't you, to get?
It's probably about an hour, about 2 hours.
Okay.
Yeah, depending on traffic.
All right, well, I'd like them to start somewhere between 9 and 10 and end on Saturday the 6th. And the expectation is that you and Jalen will have dinner together. You do not have to come up here alone, but I would like a 2-hour part of that visit to be just you and Jalen. And I could tell you what part of that, but I'm going to leave that to you. I think you can figure that out. Whoever comes with you can go do something else, go shopping while you and Jalen go to the park and spend a couple hours together, just you and her. I want to see that happen. On Sundays would be the same thing, that on the Sundays when you visit, that can expand from 9 to 6. Sounds like everyone is okay if you want to take Jalen to the zoo in Portland, and that would be appropriate also. Well, I'm not ordering overnights at this point. I think we do need to take some steps forward to give Mr. Ludwood more time with his daughter. And I think that's really what I heard in the declaration from Kai Ludwood. That's what I heard from Ms. Winkles. And that's what I hope this order does, is move us in a direction of more time. So that will be my decision. Visitation every Saturday, between 9 and 10 to 6. 2 of those hours will be alone. I think it's every other Sunday now when he comes. And 2 of those hours also have to be alone. And if Father's Day Sunday is not on that rotation, then it should be put in so that he can spend time with Jalen on Father's Day. Ms. Craig, go ahead.
Yes, Your Honor. I have already offered him Father's Day,
Okay.
just so you know, because that's his right on Father's Day. His visits on Saturday start at 1. We're starting at 1 to 5.
Okay.
So I just wanted to make sure you were clear. And then my other thing is, I know you said around 9 or 10, can we actually set an actual time?
No.
Mr. Ludwig is constantly late, and I do have other kids with other events in my life. And I just need to know a time where I need to be being able to meet him. Between 9 and 10 can be anywhere between 9 o'clock and not 10:50 something. And we run a busy house, and I am more than able to come meet him. I would just like an actual time where I'm supposed to meet him.
Mr. Agnostic, you were objecting.
I'm sorry, I apologize, Your Honor, but no. My client should be given leeway. He's coming some 90 plus miles, an hour and a half drive, traffic and various other things. He can't say he's going to be here at 10 o'clock. It might be 10:15, it might be 10:30, it might be 10:45. 9 o'clock. You said 9 to 10, but somewhere in there, he will get here and see his daughter. Now they're the ones who are confiscated his daughter from him.
I'm going to object, Your Honor.
Your Honor, I'm objecting to them requesting a specific time and this constant picking on him because he's 5 minutes late. He's coming 90 miles through Portland.
And Your Honor, I would just argue that he can leave earlier then. Leaving, if he needs to be somewhere at 9 and it may take 2.5 hours rather than 2, then to have him come on his own a little bit earlier to get there on time is reasonable, rather than having my client, who has other children in the house, including one with special needs, essentially stay around waiting for dad to show up. It doesn't make sense. We aim for a time when we have to commute, when we have to drive any distance, and we go early. That's what people do when they have a job. If his job started at 10 and he had to commute there, he wouldn't show up at 10:20 or 10:30. He would show up at 10. He would get there early. What we're asking for, if there needs to be a buffer, then that's fine. A buffer of 20 minutes, a buffer at most of 30, but a buffer of an hour is a lot to ask for somebody who's also taking care of a special needs child.
Mr. Jaden Ludwig, go ahead.
Your Honor, so if I get there early, can I get Jalen early?
Yes.
Yeah.
So if I show up at 8 o'clock, 8:50, before 9, 8:30, 8:35.
Jaden, all you need to do is call me. And I have always brought her to you whenever you've asked. You've been early. Just go ahead and call me. And
I just would like the court to say okay.
Just enough time, Your Honor, so that my client can get the child ready. If he's extremely early, she needs to be given at least 20. It's having had a 3-year-old myself, it doesn't, they don't get dressed immediately. It takes time. You have to feed them, generally breakfast. So we'd ask that he contacts her if he's going to be early, 20 minutes ahead of time, so that they know to change her and to get her ready to go.
All right, I'm going to set the window when Mr. Ludwig would typically pick up Jalen to be between 9:30 and 10. I think it is a reasonable request that Mr. Kai Ludwig and Kelly Crave not have to be waiting around for a long time. On the other hand, I think there needs to be some flexibility. And if Jaden Ludwig is going to be earlier than 9:30, then give them a call at least an hour before while you're on the road and saying, it looks like I'm probably going to be there early.
Yeah, I normally do that.
And that will, from 10 to 1, that's a 3-hour period that we're expanding that visitation by 3 hours, which is what I'm trying to do at this point. Okay.
Your Honor, just to clarify things, he doesn't meet us at the house to retrieve Jalen.
Okay.
So am I supposed to be down there waiting for him at 9:30? To wait with the 3-year-old in my car from 9:30 to 10 to see when he's going to show up?
Sure. I hear that. In my mind, you were going to be at the house, doing whatever you do, and then he would show up and pick her up.
Is there a way? I think I could be able to go up there, pick her up at the house if that's easier.
That's fine with me.
You want to do that?
Yeah, I could.
Both parties are okay with that? Okay.
We're okay with that. They've been getting along, so we hope that continues.
Yeah.
All right, let's do that, and then that window won't be as onerous on Ms. Craig. Okay.
Thank you so much.
All right, so let's try that. Tomorrow, everybody's going to get a new trial date to finish the hearing. Hopefully that'll be fairly soon, and we'll see what happens with that. Okay.
All right. Thank you, Your Honor.
Thank you, Your Honor.
Thank you, everyone.
Thank you.
Yes, Your Honor. Mr. Anagnostic popped on as well. The guardianship of Jalen Sloan, which is number 122-4-00412-08. We thought this was going to be on a Thursday. Not sure what's going on.
Yeah, I saw that too, because it looks like y'all are headed to trial. So what they listed for me was it was a motion to compel, but to be heard today, but I don't have a motion to compel. what I have, the last thing I have here, Judge Hahn on June 23rd did set this to universal trial assignment, July 12, 2023 at 1 o'clock.
Correct. We were to have trial on Friday, just this last Friday, but it was set for a half day. There's no way this could get done in a half day. Actually, Commissioner Nelson had started the trial, and so I think this matter needs to be heard before Commissioner Nelson. And it's Ms. Winkle's motion regarding discovery, and then I have a motion that I've talked with counsel about expanding visitation that needs to be heard by Commissioner Nelson.
Okay.
And
so, go ahead.
probably both of them sooner than later. So.
Okay. So is what I can do for you, I do think that with those requests, right now, the only thing, they did strike the Friday hearing. So I do see in the order that is not happening. The next thing they have for you is the July 12th universal trial assignment. Do you need a Wednesday civil docket to address the discovery issues before trial?
We need a docket and before Commissioner Nelson.
Well, I can't give that to you. So I'm gonna have to set you with someone else right now.
And I understand that, Your Honor. I'm thinking maybe July 6th on the Thursday docket, because really going before the civil on the civil docket probably won't work out for the parties because we're also doing the visitation.
Okay.
I know that Commissioner Nelson's not available throughout for an extended period of time. So I think, I'm not sure who's on that July 6th, but maybe Mr. Anagnostia and myself and Ms. Farr, maybe we can get some documents together so that we can kind of give a little background of what's going on in that case for whoever's there on the 6th of July.
And are you asking for the universal trial assignment that date?
No, the universal trial assignment on the, what day is it? The
12th.
12th is fine, but
Okay.
we do need to have a compel and a visit for myself, and then Mr. Anagnostia wants to talk about visitation. I'm thinking if we could do that at 10:30 on July the 6th in front of whichever commissioner. I'm not sure if Your Honor is hearing it.
It will, I will be out of the country, lucky me, so it will not be me, but can we put them to 10:30 on July 6th? I don't think we have a specific individual assigned to that just yet. But let's go ahead and do that. Let's strike today and move the discovery and visitation issue to July 6th. And I can reach out to court admin to let you folks know who gets assigned to that if you need to direct bench copies to them ahead of time.
That'd be great.
Okay.
And that sounds good, Your Honor. And I just asked that Mr. Anagnostia, if you just look at his chat, I'll explain a couple of things, and that would be great. Thank you, Your Honor.
Perfect. Okay, thank you. So we'll strike, move you over to July 6th, and we'll keep your July 12th trial assignment. Okay. Anything else on that first matter, guardianship of Jalen Sloan?
No, Your Honor.
No, not at this time.
Okay.
Guardianship of Jaden Sloan, 22-400-41208.
That matter is ready. Your Honor, can you hear me?
I can.
Okay.
All right, so there was a motion to compel filed, and that's what it appears that we're on for today. Looks like the trial was recently struck. Is there anything else other than the motion to compel that we're reviewing today?
Yes, visitation with my client, Your Honor.
All right. And I did receive emails. This is not the case that there was a motion to continue. So this is okay. So looks like there was a proposed order granting expanded visitation presented by Mr. Anagnostia. And then we have still the motion to compel to deal with. Is that correct?
It is, Your Honor. I'm going to ask for a continuance on the motion for expanded visitation. Mr. Anagnostou and I talked about this and agreed that because of the trial, we would hear this motion, Mr. Anagnostou's, for expanded visitation. I didn't get his amended pleadings until yesterday. I was up until 2 a.m. finalizing a response to them, which I do have, and should be with the court today after speaking to my clients. What I'd ask is that we set this over till Tuesday. That way, Your Honor can have those pleadings, which would be a reply. The guardian ad litem also, I believe, only got these pleadings on the 5th. I understand from Mr. Anagnostou's side, there was a holiday. There was some snafu with the July 3rd pleadings that were sent out. So I think, and I'm not asking for a week or anything even like that, set on the Tuesday docket would be fine with me. You can also hear the motion to compel on the same day.
So, Your Honor, numerous issues floating around, primarily caused by the fact that we had trial. We started trial. We took witnesses, and then trial got continued. That was started in front of Commissioner Nelson. We didn't finish. We had a reset of the trial to continue trial on June 30th. Right before June 30th, Superior Court Judge Marilyn Hahn issued an order that the trial was stricken for June 30th, and so now we have a reset. When that occurred, when it got stricken, counsel and I had a conversation and said, because she said, she wanted to bring her motion to compel discovery. Kind of my objection is we're in the middle of trial. Generally, you don't hear motions to compel discovery in the middle of trial. But I need the court to hear my expanded visitation, because that's what trial's all about, is to get to the next step. Commissioner Nelson said, I'm not going to expand visitation because we have trial on June 30th. Well, now we don't. So counsel and I talked and we agreed that that issue should be heard. I filed the motion just to give notice to everyone that and it even reflects in the minutes on Odyssey that we're going to talk about visitation. We need to expand visitation. I have a lot of concerns, primarily that Commissioner Nelson has heard this entire case. We're in the middle of trial, and I'm not sure what his schedule is now. My client is traveling from Central Oregon. He knows all these facts. From Central Oregon, an hour and a half or so to get here for each visit. He has to come here. He's low income. He's young and working and trying to get his feet underneath him. And this trial gets continued. He needs to be able to take his daughter to his residence in Oregon, and that's what we were requesting, and that's what was going to be heard at trial. And here we are. Trial got continued, and it's a mess. It's a mess. But so I put that to your honor. I'm not sure what Commissioner Nelson's schedule is. I don't mind setting this over to Tuesday if you want to hear these. We need to get it heard sooner than later about my client's visitation. That's it. That's kind of the background, and you can kind of hear my frustration.
I completely understand. So
And Your Honor, if I might,
I don't need to hear Ms. Winkles. So a couple things. Number one, Commissioner Nelson is retired, so I don't know what his schedule is. This very well may end up being in front of another judicial officer moving forward. So that's part one, and that hopefully we can work something out. I don't know if someone's going to review the record that's been entered thus far and try to pick up where everything left off. Number two, I had a note and I didn't understand why it said visitation on there, and I only saw the motion to compel this morning. Today I reviewed this late last night. This morning is when the actual motion and declaration showed up in Odyssey. So I haven't been able to review it. It's only a couple pages long. But given the lateness, and I guess, I don't know, let me see here. I don't know if Ms. Farr received any of the information or has been able to review it.
Your Honor, I only received the motion at 4 p.m. yesterday, and I have had conversations through email with Mr. Anagnostou, advising him that I am to be notified with proper notice when these motions are filed. I think that he disagrees because he said that they agreed between attorneys to have it heard today, but the GAL is a party to the action and should be receiving the proper amount of days notice when a motion is filed. So I'm not prepared today to respond, except to say nothing has changed since the last time this type of motion was brought to the court and the visitation was for expansion was denied. And Your Honor, also, we do have a trial setting scheduled for next Wednesday on the 12th.
The 12th at 1.
I
So it's
believe.
trial assignment calendar. Okay.
Yes.
I appreciate that. Thank you. So my hope is that the parties won't have to start all over again, but what I am going to set it to the 11th for visitation. If Miss Winkles, it sounds like she's fine with doing the motion to compel at that same time. I'm not sure who the judicial officer doing trial assignments next week is, but this is obviously a very unique situation that you kind of started, and now the judicial officer that started the case may not be available to finish the case. So please make sure that you let them know that in case. My hope would be that a judicial officer is able to review what's already been done and you don't have to start all over again, unless the parties feel like that's the best way to go. So we'll set this to the 11th at 10:30. And then it looks like the 12th at 1 o'clock for setting a new date.
All right. Thank you, Your Honor.
Thank you. Your
Thank
Honor.
you. Thank you.
Over, I think
Thank
that
you
can
so
be
much.
set over. I mean, I've sent communication to her. We're working on her requests. My client's request for visitation, though, that needs to be heard sooner than later.
Okay. So her response was, okay, she said if we give her 5 minutes, she can hop on. She did say if we set over one, we should set over both. So would your preference be that we just wait the 5 minutes and see if she's ready to proceed at that time?
That would be my preference.
Okay, let's do that. We can stay on the record, but I'm just going to mute and turn off camera for now. So I see we have Ms. Farr present. Thanks for hanging in there with us. I see we have Kelly, and then is it Key Ludwig?
It's Kai, Your Honor.
Kai, thank you. We have Jaden Ludwig, respondent. Okay, I think that covers the parties present for this hearing. Thank you everyone for your patience. Sometimes when attorneys get scheduled for different dockets, we never know how long different dockets will go. So again, thank you for your patience. Let's first talk about the motion to compel. And if that sounds like the parties might be working together on that, but let me know if that's something you need the court to address today.
Yes, Your Honor. I've read Mr. Anagnostou's email to me and a supplemental discovery. I would just like a drop dead date. It's a very easy process. It just takes about 48 hours to download Google, and to download Facebook takes about 4 hours. I just asked that it be turned into me by no later than Monday at 4 p.m. It should be adequate time, and I'd ask for the entire file and nothing to be deleted. There is a little file that tells you if something's been deleted, but rather than have to come back in on a compel, I'd rather just have the entire file.
Concerned about that, Your Honor. If we could have
Okay.
it for July 24th. I have my IT guy working directly with Jaden, and we think we have the issue solved to get those downloaded. I don't know anything about it, so I'll try to get it to her by Monday, but for a drop dead date, if we could do the following Monday, just in case.
Ms. Winkles, and I'm just looking at trial. You guys will be on universal trial assignment tomorrow.
Correct.
So
Yeah.
it doesn't seem like the 24th would run afoul of preparations for kind of ultimate resolution of this case. Would the 24th be acceptable to you as the drop dead date?
Yes, because if there was an issue with the trial, I just asked that it be 30 days out. I have the trial books ready. That would be the only thing I'd be missing. So that's fine.
Okay. Okay. So what the court will do is then note that as far as this motion to compel is concerned, the respondent will have until July 24th at 4 p.m. to provide that discovery to Ms. Winkles.
And I just asked that that I'd be allowed to put into whatever order a full and complete discovery. We've had people in the past try to delete some of those files. So I just asked that full and complete. We're asking for essentially the Google takeout download and Facebook download.
And then the Facebook full and complete Google takeout and Facebook download. I can put that into a bench order.
Thank you, Your Honor.
Anything else?
Not on that, Your Honor.
Okay. So then, Mr. Anagnosto, it sounds like the remaining issue is your client's request to change overnight visitation. Does that sound correct?
Correct.
Okay. So I'll let you go ahead on that. I will let you know I have received the GAL report, the supplemental, GAL report, which does address that issue. I have the declaration of Kai Ludwig. I also have the respondent's bank statement showing hotel charges that you filed with the court. And I have the declaration of Jaden Ludwig. I have received and reviewed the declaration of Teresa Ludwig. Is there any, and that did also include picture attachments. Is there anything else that you believe the court should have for purposes of this hearing?
There was a declaration of Michelle Harrington.
Let me go back through my paper. I don't have it digitally, but let me just see if I have it in a hard copy. I reviewed these yesterday I reviewed these yesterday morning. So if it came in after that, I may not have reviewed it.
And I don't believe I've reviewed it either. What time did it come in so I can read it really quickly?
I could ask I'm not sitting at a computer that has my
Would it be Amanda that would have sent it?
Andrea, yeah, she would have sent it yesterday. I know we went over and filed it with a bench copy with the other documents. That was around noon. She would have sent it to you before then. So somewhere around noon or so.
Okay, I have reviewed that. Ms. Winkles, let me know when you have had a chance to look.
I'm ready.
That. Okay.
Yes, Your Honor. So, I'm going to start off by telling Your Honor that I'm going to make an argument to you that in 33 years of practice, I have never made this argument before, but I'm compelled in this case to make this argument that the petitioner's quest to obtain custody of Jaylyn, they have become evil. They're just doing downright evil actions in order to obtain custody of Jaylyn, and it's wrong. For example, in several declarations, the petitioners have referred to Ms. Harrington. They've referred to her age. In Kai's declaration that he filed here on page 5, you'll notice he mentions her age twice. It's my point, this is age discrimination. Somehow, Ms. Harrington's age is a factor for my client getting his daughter returned to him. And I'm, why is that? I mean, it would be similar if they were saying, if for example, my client had a relationship with somebody who was black, and they put that in every declaration. Well, so-and-so, and she's black. And well, here they say, well, Ms. Harrington, well, her age is 54 years old, and they do that every time, and it's wrong. This shows a bias, and I don't have any room in my life for bias to play a part in these cases. Now, the next thing they do is they, in their declaration, state that the child, that Jaylyn, has been around Michelle's son. And they base that on inappropriate hearsay of a child. Hearsay of a child is not admissible. It's not admissible. As you're aware, they've now put his picture in police reports and stuff. He is, a convicted offender in Oregon. They're trying to basically, this is my point. This is why this is evil. Jaden, if you go after custody of Jalen, we're going to try to have Michelle's son thrown in prison. We're going to do everything we can to have him thrown back in prison. How wrong is that? I mean, that's what that allegation is all about. Miss Farr jumps on the bandwagon. She says she interviewed the child. I don't know how she interviewed the child. I don't know if that was in person. I doubt it, because she's always professed to me that she doesn't do in-person contact with the child or the party. She hasn't seen my client with Jalen at all, never. So I'm not sure how she interviewed him. If it was over Zoom, were the petitioners there? Were they in the background? Had they prompted her before Miss Farr talked to her? And the point is, she said, I don't know, she had a number in her report 3 times or 5 times or some number that Jalen referred that she was at Michelle's house. And my client went, thank God, modern technology, your cell phone tells the world where you're at all times. So he went out and he got the pictures where they had taken pictures of her at the hotel room. This is one, he only gets over both a Saturday and Sunday, like every other weekend. And this was one of those times when he had a Saturday and Sunday. But he has to take her back at night. But anyway, his cell phone showed where they were at. They were at a motel room, and the pictures indicate that. So, I don't know Ms. Farr's background in questioning a child, but it's easy. First of all, it's hearsay. It doesn't come in. But it's easy for me to comprehend that a 3-year-old child might think a motel room is Michelle's house. Or at least she might be led into thinking that by adults who question her in an inappropriate manner. This is not a CJAC interview. It's totally inappropriate for them to come in and say that Jalen has been around Michelle's son, because that can now send him to prison. That's how bad that is. And it's just pure evil for them to try to do that. And I'm just making this point to the court to know what lengths they're going to go to try to get custody of Jalen. And Your Honor's aware that we started trial on this in front of Commissioner Nelson, and it got continued, and then now we're going to have to start trial again. But they go on to claim that my client assaulted. They use the word assaulted Miss Crape, and the guardian ad litem, Ms. Farr, has picked up that word. She has it in her report. My client committed an assault. It is absolutely not true. There was no assault. That's a criminal charge. If you want to bring a criminal record that where my client was convicted of some kind of assault, show us, bring it to court. They don't. They blink police reports, and it's interesting, very interesting, that they submit this is their declaration they submitted of Teresa Ludwig. In the declaration at the police report, Teresa Ludwig says, Caitlin grabbed Jaden around she grabbed my client, Jaden, around his waist in a bear hug and put him on the ground. Kelly came up, grabbed his hair, and Taylor came around Kelly and kicked Jaden. And then her declaration goes on. So they submit a declaration where Kelly Crape had attacked my client. And that's what he's always said. She attacked me. Now, she went and she got a protection order, but protection orders have a very low bar. All you have to do is say in a protection order, I'm afraid of this person and I don't want them to be around me. Nevertheless, every declaration we hear my client committed assault is just not true. It's not true. And they're presenting arguments that are not supported by the evidence or the record. Now, it's important to note that when she got a restraining order, that at trial in front of Commissioner Nelson, Ms. Crape acknowledged that while the restraining order was in place, Jaden had no contact. My client had no contact. And if he had contact, she would have made sure that he went to jail. If he showed up to see his daughter, she would have made sure they went to jail. And so everybody agreed that while they believed the restraining order was in effect, my client didn't have any contact with his daughter. And the court rightfully was going to say, well, I'm going to discount that period of time because, showing up to see your daughter results in going to jail. That's a deterrent. And so Your Honor needs to be aware of that was all discussed. It was in the process of being tried, that very issue, yet they bring it up. They continue to bring it up that he went a long period of time without seeing his daughter, and ignore the fact that there was a restraining order against him that had he done so, he would have went to jail. And then when he finally found out that the restraining order was lifted, he went to show up to pick up his daughter. They called the police. And that led to the beginning of this action. You'll see that all at the beginning of this action, based on that, they got a emergency ex parte order that Jalen stay with them. And here we are 10 months later, still trying to get to the trial on this issue. They're trying to take advantage of the fact that they had a restraining order against him. That if he showed up, he would, be arrested. That's an evil argument to the court. And they're hiding the fact when they say he didn't see Jalen for a period of time, that fact that they had that order. Next, Ms. Farr again brings up that my client signed a power of attorney. If Your Honor would look at that power of attorney, it clearly ended. It ended. By the terms of that power of attorney on page 4, January 3, 2022. That's what it ended. Yet in every declaration, I continue to hear about this power of attorney. He signed the power of attorney. He signed the power of attorney. He signed the power. Okay, but it ended. So they were supposed to return Jalen to him when it ended. Well, the power of attorney has no effect. They agree it has no effect, but he signed it. Yeah, but it was self-ending. I mean, so they want you to focus on one part of it and not acknowledge and try to discount the other part of it, that it has ended and my client is entitled to have his daughter returned to him. I had a conversation with Ms. Farr about that, because I actually had my client sign a formal revocation of that power of attorney. And she called me and said, well, he didn't have to sign a formal revocation. It ended automatically. Okay, Ms. Farr, then why do you bring it up every time we go to talk about it, about this power of attorney? So my client, was down and out. You can see the evidence. He was down and out and was struggling. He's young, 21 years old, and he signed a power of attorney for on a temporary basis while he got on his feet. He's on his feet now. He has a full-time job. He's has housing available at his grandmother's house, and we've supplied pictures of the residence where Jalen will be living. This is the house, coincidentally, that Kai Ludwig lived in with my client and his sister. But now all of a sudden that house is no longer, a place where Jalen should be. So, and then they have the wrong address and they try to disparage Teresa Ludwig's house. And we've supplied pictures. We've supplied the pictures of the daybed where Jalen will be sleeping. She's, going to be very well cared for. Then there's a bunch of standard allegations. I guess I can't claim that these are evil because you hear them in every case, Your Honor. He doesn't feed her right. He doesn't dress her right. She doesn't get naps. All those allegations are denied, and it doesn't prevent somebody from having custody of their child. And to prove that, my client has now started taking pictures of every visit, showing what she's dressed in, showing her taking a nap, showing him feeding her various meat, because we have to apparently document all this stuff, or else we're going to continue to hear their baseless allegations that he's not doing that, and it's just not true. It's concerning to me that the guardian ad litem has never seen my client with his daughter. Witnesses for my client, 5 minutes around him, they obviously recognize the close, loving bond that he has for Jalen and she has for her dad. But the guardian ad litem has never seen that, never seen my client with her. And lastly, the petitioners are now complaining about me. They've thrown in the fact that they don't want my client Jaden to have a court-appointed attorney. That is wrong on very, very many levels. That's not their issue. What they want is, because they have more economic power and they can afford to hire Miss Winkles, they want my client unrepresented so they can, kick the crap out of him in court and win this case. That's how bad they want custody of Jaylyn, and it's just wrong. It's just evil for them to challenge my appointment as court-appointed attorney so that Jaden is represented in this action. My client makes a little bit above minimum wage. He's solved his housing issues. Jaylyn will be living with the grandmother, Teresa Ludwig. This is, as I indicated, a resident that where Kyla lived in the past with children. My client has looked into obtaining a daycare for Jaylyn. She'll be in daycare. She goes to daycare every day at the Ludwig's house. So they're not providing, the day-to-day care. So that's not a change. That's, that he'll find a pediatrician in Toledo, Oregon, where he'll be residing with her for Jaylyn. He needs custody of his daughters. So cut to the chase. This is what I believe is going to happen at trial. It will be shown that my client is willing and able. That's the standard under guardianship. To parent Jaylyn. Custody will be summarily granted to him, and the court will order a turnover in a very short period of time. Now, I have cites for 3 Calais County cases, Your Honor, that where the court has specifically summarily returned children to the parent. And I'm not sure if you want those cites or not, but it's several cases, and counsel and I have been involved on these, and the order is you will turn over the child tomorrow or in a couple of days, or it's never more than like a week. It's like this Friday, we're on a Tuesday docket and they say you'll turn over the child this Friday. And when we go to trial, that's what's going to happen. That's what's going to happen, I believe. Again, if you want case cites of local cases, I can provide those. So my thought, this is just me, and this is the reason for this motion. We were working toward expanding visitation. Commissioner Nelson was doing that. We need to go to overnights and continue this process to work towards a smoother transition of Jaylyn into my client's household. That's the reason for this request. It's for her best interest, and so we want to increase the visits to overnights so that my client can do those parenting aspects of overnights. And they don't want that because they don't want proof to come into trial that he can put her to bed and get her up in the morning and feed her breakfast and dress her and all that kind of stuff. But when we go to trial and the court summarily returns her, that's exactly what's going to happen. It's going to be just a turnover right now. So our request is that we expand visitation while we're in this process of getting this to trial. I understand that we held off expanding it because we were in the middle of trial. We're going to finish trial, but now we're going to have to start over on trial. And so this needs to happen. The court needs to expand the visits because the petitioners don't see the handwriting on the wall. They're doing everything they can to avoid it. And they're going to lead us into a position where Jaylyn is summarily returned to my client.
Thank you. Ms. Winkles.
Yeah, there's a lot to unpack there. First off, I think it's necessary to kind of go through what the actual legal standard is here. So first, we have 2 legal standards, and the trial is actually not just the trial for the emergency. The trial is also for the minor guardianship. And the basis for minor guardianship is clear and convincing evidence that no parent of the minor is willing or able to exercise parenting functions as defined by RCW 2609-004. What those parenting functions are things such as making good choices for the child, having a place for the child to live, being able to personally provide for the economic necessities of the child. There's a lot of other things there. But I'm going to go and start in the same order Mr. Anagnosti does. The age difference. The age difference is not age bias. In fact, it's showing the reason that the age is there is because Jaden has a history of attaching himself to older women, including his grandmother and Michelle Harrington, nothing about her age there, about his age, and essentially mooching off of them. He doesn't provide for himself. He lives with them. He lets them do all of the parenting functions of his child. He essentially gets kicked out from one home to another, essentially using these women's economic status. That's why her age is mentioned. There is no bias here. The GAL is court appointed.
Apparently, when she goes for Mr. Anagnosti's client, she's fine. When she goes against, she's suddenly biased. The fact is this is a woman that has interviewed everybody in this case, has done more interviews on a lot of people in this case. My clients don't fully agree with her, and they believe that the thresholds should be even higher. But she has interviewed the child. And this is the thing. This child disclosed that she was taken to the home of a registered sex offender. Now, she didn't say that.
I object to child hearsay, Your Honor.
The GAL is allowed to report on anything told to her. And in her report, she clearly identifies having spoken to the child. It is not child hearsay.
Yeah, and my ruling will just be that I am going to allow it, and I'll obviously, I think that objection goes to the weight of the evidence, but not its admission. So go ahead, Ms. Winkles.
So we have dad who, I guess starting from the very beginning, this is a man who didn't bathe. You'll see in the declarations of Melody Boone, you'll see in the declarations, these are for CP 47 through 49. They talk about he didn't work. He pretended to work. He smoked marijuana. He had a domestic violence allegation in Lincoln County. He then has this assault where he was arrested. Mr. Anagnosto makes it sound like this was a man that was not arrested. This man was arrested for assault. When you hit somebody, it's an assault. Whether or not you're convicted is a different story. But we're not in criminal court right now. We're in court for minor guardianship. So he has a DV that's not even attached to this case in Lincoln County. He then is arrested for assault. You'll see the photos of my client's busted lip. The reason he was taken to the ground is because you'll read the statements, which Mr. Anagnosto fails to continue to read, that talk about how he was attacking my client. Teresa Ludwig, one of their witnesses, states that in her complaint, that they're in her declaration to the police, she was doing everything she could to get him off of her. Everybody was. The fact is, this man can't control himself. You'll see that in other court cases we've had where he essentially yelled at Dave Nelson out of the blue. This is a man who's never been able to keep a job. This is a man who got kicked out of Teresa Ludwig's house for failing to take care of his child. This is a man that a woman with no horse in the race, Melody Boone, says he essentially did nothing for his child, would leave his child in dirty diapers and would just smoke pot, play video games. He didn't even know where his child was at times. We then hear about him being kicked out of another house. What does he do? He drops the child off. Why this document that he signed is so important was because this is a man that decided he was going to drop his child off for a period of time with my client. So apparently these horrible, evil people are good enough for him to drop his daughter off with them and leave them. Now, this is important. They didn't have a duty to go drop the kid off after 6 months. This is the father. His duty is to go pick up his child. The fact is he didn't. He left the kid there and he never called. He never texted. And the reason this is so important is because the restraining order was between him and Kelly Craig. Not between him and the child, not between him and his father. In fact, if you'll see by Kai Ludwig's declaration earlier on in this case, you'll see the text messages where he actually texts his son. And he said, please call me, please text me. They're essentially trying to get him to contact his child. He doesn't. He ghosts this child for over a year. It's not interested. He's not interested until his grandmother pushes him into it. Tells him he needs to be a father and pushes him. And then suddenly he wants to be a dad again. He was always allowed at the house. There was no restraining order on the house. The restraining order was purely against Kelly Craig in person. She could have left. Kai Ludwig told him that. Did he do it? No, he had no interest in this child whatsoever. And I say that very specifically because I think it's really important to understand this was a child that dad didn't get vaccinations for. Fair enough. Some parents don't. This child was essentially deaf for a period of 18 months. She couldn't say one word because she couldn't hear. Did dad take her to the doctor ever? No. This child was so developmentally delayed that normal children are speaking almost full sentences at by this point. This child couldn't even say hello because she couldn't hear. He drops essentially a deaf child off that he has had no, what is he doing? What is he spending his money on? What is he spending his time on? He has no job. So why not take this child to the doctor? He doesn't. Instead, my clients take this child to the doctor, find out that she's deaf. She has surgery on her ear. She can finally hear. What do? They take her to the daycare where my client works and they work with her. They put her in a special program. Dad is of no help. They work with her every day. That child is meeting milestones now. Had that child been left in dad's care, that child would probably be incredibly developmentally delayed at this point, and there would probably be no hope of getting that child to a milestone. The fact is this child has only survived, been able to speak, been able to hear, been able to learn because of my clients, nothing to do with dad. The fact is that dad makes choices for dad. Dad makes choices for ease. Dad does what is easiest for dad to do. Where can he smoke weed? Where can he not work? Where can he sit on his rump and not do anything? And he picks older women to do that, be it his grandmother, be it Kelly Craig, be it his current girlfriend. The fact is we were already here on this in April, and Commissioner Nelson did not expand visitation. And the reason for that is because dad has done absolutely nothing to change his place. He took an online parenting course. That's it. Did he go to an in-person parenting course? No. He got a job. Fair enough. This is the longest job he's ever had. We don't have any information about this job, though. This is a man who once pretended he had a job and would leave and go smoke weed. So take it with a grain of salt. And that's the issue with him having a court-appointed attorney, is if he has a job now, why isn't he paying? Because my clients can't afford me. The fact is, you'll see a notice of withdrawal that was in their file before. They can't afford me. The fact is, we're not going to a trial again. They can't afford me. And yet Mr. is the reason for this, leaving essentially developmentally delayed child. Yet he has a job. Why isn't he doesn't pay child support? He doesn't pay anything. So why is he not paying for his lawyer? At least child support or lawyer, one or the other. With the assault of my client, it's clear. It's really clear what he was arrested on. The fact is that none of the witnesses testified against him, being Teresa Ludwig, and so it was dropped. The DV in Lincoln City, I think, says it all, and we filed that with the court. There is testimony from a lot of different people that will confirm that my client was beat up. Again, the restraining order, that was only between Kelly. Why didn't Dad care for a year? Why didn't Dad try to do anything for a year? Why didn't Dad come to see his child? He essentially left this child with these evil people doing nothing. Yet this child has flourished in their care. They don't want to keep this child from Dad. They want Dad to grow up, to get his own place, to keep his job, and to be able to take care of himself and the child. This is a man who didn't bathe for a month. This is a man who essentially moves from house to house, and here he's doing it again. He's now going to move back to a house that he was already kicked out when he had his daughter. He was already kicked out of grandma's house. This is a child that's going to be sleeping on a daybed in a living room. And this is a child that currently has a room. She's going to be sleeping on a daybed in a living room at grandma's house. Now, my question is, Dad has a job now that's 2 hours away from where grandma lives. We have asked Dad repeatedly, where do you live? Do you live with an ex-offender or do you live with grandma? He refuses to state clearly. He always says, if I get the child, I'm going to move here. The fact is, we have no way of knowing that. This is a child that already disclosed she was being taken to a house where a man that a minor girl lives. Now, we're not trying to screw up this guy. We don't know him. We don't know him at all. My clients don't know Michelle Harrington's son. This is a civil matter. This has nothing to do with criminal charges. Even if this matter, they determined it was more likely than not that the child was around the sex offender. This has almost nothing to do with a criminal matter unless somebody takes it to the police, and it would have to be a reasonable doubt standard. The fact is we're on a different legal standard here. But this is what the child said. Now, has Dad done it every single time he's had visitation? No, which is why we were here on the discovery issue. The reason for Google Takeout is it does follow you. It follows you every single place you go. And the fact is that data is going to show that Dad absolutely drove that child to Michelle Harrington's house. It's going to show that he absolutely did. Even if you turn off your phone, it still follows you. And the fact is that it shows you, if you delete even one file from that program, it will show you. And the fact is they've done nothing and put no evidence in this court to prove otherwise. They put a few hotel receipts. Well, that's great. What about every other time? And if this man wants his child so much, I ask you, why is he always late picking her up? He comes an hour late, doesn't call. He drops her off early. He drops her off wet. He dropped her off this weekend with a massive sunburn, which we'll be presenting at trial. This is a man who always has somebody with him. Now, people have made statements that he's been with the child for an hour here, an hour there. That's not enough. The fact is he's going to do what he's always done here. He's going to delegate the authority and the parenting to an older woman. While this might be okay, the fact that Dad took that child to that sex offender's house and that Michelle Harrington's declaration didn't say anything about protecting the child. I think this is really important. The tone of Michelle Harrington's statement is all about protecting her son, the most important person, obviously, to her. This tells the court that she's not going to protect that child. The first thing she's going to do is protect that son. If that child goes there and gets molested, is anybody going to tell the truth? Most likely not. Michelle Harrington is going to protect her son, which is exactly what the tone of that statement is. How is Dad going to work 2 hours away from where his daughter lives and where he lives? The fact is he won't have a job again. He'll be right in the same place. The parenting functions in RCW 26.09004 clearly state that you have to provide for the financial support of the child. How's he going to do that if he doesn't have a job? It means that adequate education for the child, including remedial education, essential to the best interest of the child. Child was developmentally delayed, didn't say a word, Dad did nothing. Assist in maintaining appropriate interpersonal relationships. Being around a registered sex offender that was convicted of rape of a child is not an appropriate interpersonal relationship. Attending to the daily needs of the child, such as feeding, clothing, physical care. Dad doesn't even bathe himself, and yet only took an online parenting course. Nothing has changed. If we look at the emergency order, it says a willingness and the ability to protect for the health, safety, and welfare of the child. This is a man who took a 3-year-old little girl to the house of a registered sex offender. He may have a willingness, but he definitely doesn't have the ability, because anybody with the ability to parent would make a decision not to take their child to the house of a registered sex offender. Anybody with a willingness to provide for the health and safety of a child would have a job that was less than 2 hours away from where the child lived. Anyone that would provide for the health, safety, and welfare of the child would not let a child be deaf for a period of 18 months while the child said absolutely no words, had no vaccines, and essentially never seen a doctor. This child is only possibly alive today, or at least thriving today, because of Kelly Craig and because of Kai Ludwig. Kai Ludwig loves his son, wants his son to become a man. Giving this child back to Kai Ludwig will be absolutely detrimental. It will be something that is irreparable. He can wait until trial to present his case and prove to the court that he's done some change, because the fact is right now he's a danger to that child. He's not just unfit, he's an actual danger. All it takes is for him to take that child once again to that house and for something absolutely horrific to happen to that child, or for him to fail to acknowledge another medical need and do nothing. And if we're relying on Michelle Harrington and Teresa Ludwig, that's inappropriate. They're not petitioners in this case. They're third parties that have no interest whatsoever. They're not the natural born parent. They're not married to Mr. Ludwig. He would essentially be delegating his parental authorities to another person who the court has not investigated, and that itself is not appropriate as well. I ask Your Honor to continue visitation as it is, to let this matter go to trial on the minor guardianship, to put forward the emergency guardianship. Procedurally, we've done it wrong. It should have been this type of hearing the whole time, a show cause hearing on the emergency, and then go to the minor at trial. That's why I put in a trial setting notice for the minor. The minor will be heard, will go on the trial setting docket on the 12th. At this point in time, the court doesn't have enough information from Mr. Ludwig himself to prove that he's safe. He's provided a few pictures showing the child eating fast food. He's provided nothing else but self-serving statements. There's nothing about his income. There's nothing about his ability to take care of himself. There's nothing about taking the child to the doctor, none of that. It's all from my client showing that they have taken over the responsibilities because Mr. Ludwig just doesn't have the ability at this time. Thank you.
Thank you. Mr. Ludwig, I see your hand. Mr. Anagnosto, do you want to talk to your client or advise him whether to speak during this hearing or not? I'll leave that to your discretion.
Jaden, if you just listen at this point, and then we'll listen to Ms. Farr, and then I think you and I can have a conversation, a breakout room, and then come back, if that's permissible, Your Honor.
Yes, absolutely. Ms. Farr, go ahead. And I just want to be a little bit cognizant of time. The clerk and I both have docket at 1. We will have to take a break. So I have read your report. I value your input. I'm just trying to point out the time. So I'll turn it over to you at this point.
I'll try to be quick, Your Honor. Procedurally, this case is way off track and we need to get it back on track. Procedurally, the emergency order should have already been put in place. I filed my report in January. The emergency order should have been put in place then. The trial should be now being set for the standard petition. I was appointed in May as the GAL to continue on the standard petition, but I haven't been able to get into the crux of things because we still don't have an emergency order in place. That has to come first procedurally. So under 11-130-225, the court should enter the emergency order. Going forward, just to address some of the things that were said today, I have never made a reference about Miss Harrington's age. So there's no bias from me on that. I don't care how old she is. That isn't an issue for me. It is the issue for me is whether the child is being properly cared for and protected and safe. I have never said anything derogatory about Miss Harrington's son. When I filed my supplemental report, I said that the child reported that she has been to Michelle's house. I made no mention of the child saying that she had been in or around contact with Miss Harrington's son. I don't have any information about that. I haven't finished interviewing the father about that. And I did say that in my report as well, that wasn't a completed investigation. As far as Mr. Anagnosto keeps bringing this up about me not interviewing in person. There's two issues here. First of all, my order that appoints me allows me to interview by by Zoom. It says that I don't have to interview in person. I conduct all of my investigations this way. I've never had a problem with it. I recognize that there is a loving relationship between the child and her father. It is not necessary for me to see that in person. I am not a supervising, I'm not a visitation supervisor. That part is not my job. I am well qualified in interviewing children. I've had extensive training. It is in my statement of qualifications. As far as the power of attorney goes, Minister Anagnostou is correct. We had one conversation about that. It was through email. It was not a verbal conversation. So I don't know where that disparaging tone of voice comes when he's mimicking me. That doesn't make sense to me at all. And I've never brought that up except in my initial report when that power of attorney was signed. And it was revoked. And I do believe I acknowledged that. But the fact is, it shows that the father trusted the petitioners to leave the child in their care. That's what the signing of that power of attorney means. The goal is to return the child to the parent in all of these cases when the parent can properly parent that child and it's safe for that child to be returned. At this point, we're still in a phase where there isn't an appropriate place for the child to live with the father. The father hasn't provided any proof that he is able to provide for that child and meet the statutory requirements to provide for that child. And nothing has really changed. All these hearings that we've had, and there's been multiple hearings, and at each one, the overnight visitations come up. Nothing changes from hearing to hearing. So there's no reason to expand those. His day visitations have been expanded. Nothing has changed with that. The same thing keeps occurring. As Ms. Winkles brought up, that pattern of being late, the pattern of not providing for the child, of, she was returned with a sunburn. I mean, all these things that he still isn't able to parent during the daytime. So the overnights are inappropriate at this point. And so just to bring it to a conclusion real quick, my position is that we need to get the emergency guardianship order put in place, get the trial set for the standard petition so that I can dive in and do my investigation on the standard petition. And, the other thing is that I don't know if this will do any good to bring up, but I would just like a little bit more professionalism in dealing with all of this, because all the derogatory and dramatic accusations, they're just fueling fire between the parties. It's not helping. So, it just would be good if we can just stay on the focus of what is best for this child instead of attacking each other.
Thank you. Mr. Anagnostou, did you want a breakout room with your client?
Just for a minute, Your Honor. I appreciate it. Thank you.
Ms. Jaden Ludwig, do you have capabilities to enter a breakout room with your attorney? Okay. Mr. Anagnostou, how do you want to proceed?
Well, I want to proceed to a ruling on my motion. Just as a rebuttal argument, just a couple of points, Your Honor. Where we're at in this case is the petitioners filed an emergency guardianship. We requested an evidentiary hearing, which is allowed on emergency guardianship as opposed to just declarations. It's a very low bar, though, on the emergency guardianship. We were in the middle of the trial, the evidentiary hearing on the emergency guardianship. Ms. Winkles had put on a couple of witnesses and we ran out of time. And so we were in the process of resetting the emergency guardianship. We ended up here. We had it reset and then it got summarily stricken by the court when Commissioner Nelson retired. Commissioner Nelson started the trial. You heard testimony, and here we are. So it's my understanding that Ms. Winkles wants to try both the emergency and the main, I call it the main, the main guardianship action together. They do have different standards and they do have different elements, but she indicated to Commissioner Nelson that that was permissible. We could do the trial on both of them at the same time. So I'm just responding to Ms. Farr's statement. The emergency guardianship is not before the court today. The only thing before the court is my motion to expand residential time. If we're going to do the emergency guardianship, I agree with Ms. Farr. We need an emergency guardianship order and a ruling on that. If we're going to do them together or if we're going to do them separate, that's up to your honor to decide. We need to get this moving along. In the interim, my client gets every weekend with his daughter. One weekend he gets a day visit. The other weekend he gets both a Saturday and Sunday. We want those to the Saturday, Sunday ones to be overnights. He has to come up here and generally spend the night anyway. And he should be allowed to feed his daughter dinner, get her up in the morning, bathe her, those type of things. And he's being prevented from that because, it's absolutely clear to me why, because they want to come into court when we do get to trial and say, well, look, he's never had an overnight, well, go figure. The court hasn't granted, and they're not going to grant it. They say they want this to move along, but the petitioners absolutely are doing everything in their power to not have this move along. Now they're attacking my client's son, which is still a concern. And counsel has brought that up in her argument as well, continuing to say that Jaylyn has been to Miss Harrington, thank you, Miss Harrington's home, which she has not. Inappropriate interview by the guardian ad litem of a 3-year-old child. I get to point that out. Miss Farr indicates that there's conflict, animosity in this report. Well, yeah, when you ignore the evidence that my client has provided, first of all, you don't talk to my client at all to begin with, and then you ignore his evidence of cell phone records and those type of things, saying this is absolutely not true, and you still promote that Jaylyn has been around Miss Harrington's son. That's just wrong on many levels. But so anyway, my response, Your Honor, is we need you to straighten this case out procedurally, and in the interim, while we get this going, my client on those alternate weekends should have his daughter. If you want to enter an order that says he cannot leave the state of Washington with Jaylyn, that's fine. He's not going to leave anyway. But we can put orders in effect, and he can start having overnights. But God forbid, the petitioners don't want that because they don't want that evidence presented at trial.
Thank you. Thank you to the parties for the written materials in reviewing and your oral argument today. I have reviewed the extensive history in this case, and let me start with the procedural issue, which I do see here. Here's what I see. Certainly parties jump in and correct me if I'm wrong, but initially there was an emergency minor guardianship put into place. There were a few extensions. The most recent one I can find is March 23 of 2023, and it looks like that ran through May 5th of 2023. And then there was supposed to be there was the start of the evidentiary hearing that ultimately had to be rescheduled. So I do think we need to either today or at a date very soon come back together to discuss or somehow address the lack of an emergency minor guardianship order in place. What are the parties' requests on that? I know, Ms. Winkles, you talked about a dual trial on that.
I didn't really. So
okay.
That's the thing. It's not an evidentiary hearing. You don't get to request that. I'm not sure what statute Mr. Anagnostou is coming up with that. That's not the case. It's a show cause hearing. There's no testimony. If the parties are pro se, their testimony is in written statement only. You have to do a special motion before the court to request any in-person testimony. So I'm not sure where that came from. When I set this for trial setting, I set it for the minor guardianship. Dave Nelson put them together, but it's not appropriate. It should have been a show cause hearing. It's the immediate order is supposed to last 5 days. Then the emergency order is on a show cause. You don't have time to even do a motion to request testimony. So it's not a thing. There's no evidentiary hearing. It's all based on the pleadings. So it's supposed to be 60 days and then another 60 days and then possibly to trial on the minor. We didn't do that here, but that's what's supposed to occur. It's clearly laid out in the statute. There's only one case so far. But the timeframes tell you that it's not going to be an evidentiary hearing, or the statute says that. It literally states it's a show cause based on the order, the mandatory forms themselves.
Do you anticipate noting this on for a show cause on the emergency, since it looks like there's not one in place, or what are the petitioners planning?
We can do that. I mean, essentially what we've done today is a show cause, but if there needs to be additional argument, I have no problem putting this on for a show cause hearing for next week, because it is supposed to be within a very short time frame for the emergency, and then the immediate is supposed to be within, it's the immediate, and then the hearing's supposed to happen in 5 days, which is frankly nearly impossible. But I can definitely note this on for next Tuesday.
Mr. Anagnosto, would you be available next Tuesday for us to address that procedural issue as far as whether or not the emergency minor guardianship can be put into place? And I frankly would be inclined to do it today, but I want to afford you that opportunity for additional time.
So this would be on the 10th. I have one matter already on the 10:30 docket next Tuesday, so I'm here anyway.
Okay, that would be great. Let's go ahead and do that. I want the parties to know, obviously,
So
go ahead.
If I can just briefly respond, because it's my understanding those ex parte emergency orders are evidentiary, and there's a requirement that you put people under oath. I know there was a case I was involved in where people weren't put under oath, and it was overturned on a motion for revision. And basically, Commissioner Nelson required to make sure people were under oath during those hearings when they provided testimony. And that was an emergency.
So what we'll do, let's put this on for July 18 at 10:30 to essentially address the show cause for the emergency minor guardianship. Ms. Farr, are you available? Okay. And as the parties know, since I'm newer to this docket, Mr. Anagnosto, I will do research ASAP into the evidentiary component of that type of hearing.
Sure.
And I will email the parties this week with my understanding of what I would expect for that hearing, so that we're all on the same page and you can really prepare your clients.
Right.
So I will get that taken care of in the next 48 hours. I'll just, for the record, kind of go through, I understand procedurally how the visitation issue has worked through this case. I do see that the visitation issue has been addressed at several hearings. Additional evidence was presented for today. Most recently, I show on May 16 of 2023 that Commissioner Nelson held a hearing on expanding visitation. And he, at that time, issued a decision expanding daytime visitation beyond what it had previously been. But he declined specifically in that ruling to add overnight visitation. Based on the court notes from that hearing, my understanding is that he wanted to see additional steps taken by the respondent father before adding overnight visitation. He did not outline what those additional steps would or should be. But as I look back at the record and I hear the testimony today, I can, I guess, put myself in his shoes at the time of that hearing and kind of walk through what additional steps a judicial officer probably would want to see before adding overnight visitation. Clearly here, I don't view these petitioners as trying to keep the child from the respondent father. I think I have seen cases like these where the petitioners are requesting all sorts of restraining orders with the respondent parents and the child and asking for no visitation. And I don't see that here. I do see petitioners who are trying to balance the safety of a very young child who, I guess, given the age of the child, there's heightened concerns the court would have over, whether that child could properly report, whether there were any abuses of visitation or court orders. So I think that Commissioner Nelson was carefully crafting visitation to balance both the father's interests in being with his child, but also the need to protect the child given some of the issues that have come up in this case, and of course, pending a full trial. I understand that one of the additional steps the father has taken is to take an online parenting class. Kudos to him for that. I think that is a step in the right direction. It is not a step far enough for me, though, to change what the court has on numerous occasions indicated should be safe visitation standards in this case for now. So I am going to decline to add overnight visitation at this time based on the evidence in front of me and the record in front of me. I do think that the court has throughout this case struck an appropriate balance again with the father's interest in fathering his child, but also in protection of the child. In making this ruling, I also take into account that we have outstanding discovery issues regarding social media accounts and other technology issues that could in fact shed light one way or the other on overnight visitation and whether it is appropriate. And so out of an abundance of caution, I would be happy to revisit my ruling once discovery is fully shared, should that change or potentially change the outcome of my ruling in this case.
Your Honor, I have one question. My
Yes.
clients would like to have the transfers happen in a public place rather than at their house due to some of the allegations made. Can we make that happen? That we have it just, and for both parties' sake, considering what's been going back and forth.
And I'd like to point out, Your Honor, that they, at some hearing, demanded that my client go to their house. He didn't want to go.
Okay.
So we agree that we would like some neutral place.
Okay. Is there a proposal for where what public place that should be, or do you just want to leave it as a public place?
We should probably have a definite, and then my clients can leave, I believe, whatever the court had before, so they don't have to wait. Dad is sometimes an hour late, so I'd ask that they only have to wait for 15 minutes. The pizza place is what my client states.
What's the name of the pizza? And what is that here in Longview?
It's in Castle Rock.
Castle Rock. Okay.
You have to go on mute.
Your Honor.
Yes, Mr. Ludwig. Yeah, we're running a little short on time here, so I need to ask you a very pointed question, which is, are you in agreement to make Papa Pete's in Castle Rock the transfer location?
I would prefer somewhere in Longview than Castle Rock, to be honest.
And the other thing is that it sounds like they want to change it such that if he's 15 minutes late, he doesn't get visits. That's an inappropriate change.
They shouldn't have to wait all day for him.
Yes.
And Your Honor, they do not wait on me all day at all. The reason sometimes I'm also late is because due to traffic. And yes, I do leave early enough, but still something could happen. Someone could get, lanes switched down to one lane and then I'm stuck in traffic.
I probably just right now, I mean, obviously.
They are waiting with a 3-year-old child in their car.
Yeah.
And that's why, Your Honor.
They're the ones who have set this up. So
okay,
that's why I have, that's why I suggest, that's why I feel like their place was fair enough. That way they didn't have to drive anywhere with the child and wait. But Your Honor, since they're wanting to now all of a sudden change it, I see that there shouldn't be a time limit, because if they want to change it, then that's their decision.
Thank you, Mr. Ludwig. Okay, here's what we're going to do. For now, I will issue a bench order that the child transfers will take place at Papa Pete's Pizza in Castle Rock. I'm not going to put a time limitation on it specifically in the order. I do note that with summer construction, especially in Cowlitz County, there could be delays that both parties may encounter. I know there's bridge work. I know that there's I-5 work. So I don't know how that's going to impact traffic. So for now, I'm going to leave it as is, but Mr. Ludwig, I just would caution you to be as timely as possible.
And I do try, Your Honor. It's just
Understood.
like I said, it's just everything going on.
I understand. So other than those,
Your Honor.
Hold on, we have to wrap up this.
I'm sorry.
I have 5 minutes to eat and get to my next docket, as do the clerks. So I think that
And me as well.
Yeah, and everyone else. I think we've taken all the testimony we need on this matter. We've made the rulings. We'll be here next Tuesday at 10:30. If there are additional issues that the parties need to address, please note those in your written materials, and I can be prepared to rule on them at that time. Okay.
Thank you, Your Honor.
Thank you. Anything else?
I don't know what time, Your Honor. I'm sorry.
For what?
For the meet time at Papa Pete's. The order says between 9 and 10.
Yeah, that's what.
Do you want me waiting there for an hour?
That is what's still in place. You've asked for it to change from your house.
Yeah.
That's what I can offer you.
Absolutely. So what I'm asking is, I need to be there at 9, correct?
Call me. I'll talk to you.
Yeah. Perfect.
Okay. All right.
Thank you all.
Thank you, Your Honor.
So I think everyone left is for the guardianship of Jalen Sloan. So let's go ahead and call that matter. This will be number 1 on our docket. This is 224-004-1208. Okay, let's do, first of all, I know this case has a long history, and then this week some additional motions came in. So I kind of just want to go through where we are procedurally. I'll let the parties know when we were here together last, we did address discovery and visitation. My understanding was that you all had started this fact-finding hearing on the emergency guardianship, and it had to get continued. And then obviously, as you both know, the commissioner who started that process retired. And so here we are. It looks like at the time that the hearing on the emergency guardianship was continued, there was not a further order issued extending. It appears to me that that should have been done, but wasn't done. So we find ourselves in a position today where my plan was that we would be having this fact-finding hearing on the emergency guardianship, minor guardianship. But what I have now in front of me is the motion to dismiss filed by Mr. Anagnosto that was filed with the ex parte judges, I think yesterday or the day before, because they saw that this matter was on for a fact finding. They handed the ex parte motion to me. No one has signed it. They handed it to me to address on today's docket. And then I did also receive Ms. Winkle's motion for immediate order, ex parte, and restraining order, kind of laying forth that she had received this motion to dismiss, so was filing these documents as well. What I would like to do, and I'm going to turn it over to Ms. Winkles and Mr. Anagnosto in 30 seconds as soon as I tell you my thoughts here. My thought is, let's talk about those orders in a bit, but I do think we need to stick with our original plan, which was to have the fact-finding hearing on whether or not to appoint the emergency minor guardian first. That is what this was set for. I understand there's been some procedural oddities in this case. And I also wanted to check in with the parties because my understanding, and you both know I'm newer to this docket, but my understanding is that these evidentiary hearings should be somewhat short. And I'm not saying 5 minutes, but I am thinking more like 15 to 25 minutes. Otherwise, we're going to run out of docket time. And this, if you folks are thinking this is going to be an hour-long evidentiary hearing, this really should be, you know, special set or put on trial assignment. But my understanding for the emergency guardianships is that it is a shorter fact-finding hearing. Let me turn it over to the parties to see if we're all on the same page here.
Yes, Your Honor, if I can. So this would technically be my client's motion in that they were seeking an emergency minor guardianship. When we went to the trial, it was interesting. It wasn't just an evidentiary hearing. Commissioner Nelson consolidated my trial setting notice for a trial on the minor guardianship with the emergency that evidentiary hearing that Mr. Anagnosto asked for. So that is what the start was. It was both the emergency and the minor that we were starting the trial, and we finished one day of it. So we find ourselves here. And as I've stated in the beginning, today is a show cause hearing. Only the attorneys argue. It's an emergency. The way it's supposed to go is you do the immediate order, immediate motion for a restraining order. You get that. That is supposed to be heard within 2 days. It rarely is. You can go up to 14. You then have that show cause hearing on the emergency, and it's the attorneys arguing or pro se arguing. You're arguing off the declarations. You're arguing what's before the court, and then the court. The reason why it's not this evidentiary hearing that Mr. Anagnosto has asked for, where you have testimony, is because this is very limiting. you get 60 days. You can then renew for 60 days. If there is a minor guardianship petition for full in place, it can be extended till the date of the trial, but it can't go on forever. The fact is that it's self-limiting, which is why it's a show cause and not this large trial. The trial is supposed to be held within 60 days or at a maximum of 120 days. Obviously, there are some instances, such as this case, where it's going to be pushed later. And that's what's kind of happened. Now, Commissioner Nelson was extending the immediates over and over again, but we've had a ton of show cause hearings. Really, what's happened here is we had the wrong order put in. What should have been put in is the emergency minor guardianship order. Now, if I look into Odyssey, I believe one of those was actually put in at one point.
Yes.
And that means that the emergency minor guardianship, if the emergency minor guardianship order was already put in place, that means that that was already heard. And when that comes into place, this court has the ability to extend that until the trial, which is what should happen today. So we're here to argue a visitation issue, essentially. Mr. Anagnosto's client waived any procedural complaint or objection when he continued to argue and continued to set motions for visitation. That's essentially a waiver of any procedural issue that is an interlocutory order, such as a temporary order or emergency minor guardianship order. If we were here and he argued procedure based on the minor guardianship order, based on something that came to trial or whatnot, that would be a different story, and that's appealable. This is not. There's a reason for that. It's short. It's short. There's no child support. State said that. There's just what we're looking at today. So we're here, quote unquote, on a show cause for today. But in reality, the court should have just extended that same order rather than going from an immediate order to an emergency order to an immediate order to an immediate order. What needs to happen today is the immediate order needs to be put back in place. We do have a trial scheduled already in this case. The trial is set for, bear with me, we're having some internet and computer issues.
Yeah, and I think it's the week of August 28.
Yeah.
Although I think this is an error. Because I was at that trial assignment. It says week of August 28, 2024.
Yeah, we were going to bring that up. It should have been 2023.
Yeah.
And that's really where we're at. The emergency order should stay in place until that hearing. The fact is the court already ruled on it in that we have an emergency order already in place. So the court has the ability to just extend that to trial. Now we can argue about terminating that today, but in reality, the threshold's already been met in this case to put it in, which is why no objection within 10 days to that order was ever entered. And that's where we sit today. I won't argue the visitation yet because I think we're just arguing procedure. But does the court know the CP of that order? I can't. My computer is just not.
I actually, and I might stand corrected. The last thing I actually have is the March order, which was an extension of an immediate order. That was March 23rd. So I believe what we are here for is to, I think my role is to decide whether to grant an order on emergency minor guardian or not, because I don't think that's been done yet. And that's my understanding of what we would be doing today.
Yeah, it actually looks like Your Honor is correct. They're all immediate orders. So yeah, I guess we are here on a show cause, and it should be just like the show cause in all the other minor guardianships. It's not where you're taking testimony, it's where you're arguing. And in this case, we're arguing for less than 60 days.
Right.
We're arguing for a very short amount of time. So I would be in agreement with Your Honor on that, and I'll try to keep mine brief when we're ready, but I'll, Mr. Anagnosto.
Yep. Mr. Anagnosto, go ahead. I'll hear from you.
Yes, Your Honor. That's my understanding of where we're at in this case, is that there have been several emergency orders issued. and those were continued. When the trial date got stricken, there was an order from Judge Hahn striking the trial. Counsel and I got that a couple of days before the trial. I assumed that the emergencies were going to be extended. Somebody was going to extend that. I didn't realize that they weren't extended. But as soon as the trial date got stricken is when I brought my motion to expand visitation that Your Honor heard. And part of it is based on, the record that I provided to the court of Judge Nelson's rulings that he was going to consider expanding it. And so my mistake, I thought we were still under an ex parte order. And when I realized we weren't, this is a procedural issue that before the court, the court no longer has an emergency order, and therefore my Jaylyn should be returned to my client. That's our request. It should just be as summarily done. The court doesn't have jurisdiction. He's the father. Jaylyn goes to him. If they want to continue to pursue their main guardianship, that's what I call them. I call them the emergency and the main guardianship. If they want to continue to pursue that next month, we can go to trial over the main guardianship. The standards are slightly different, if Your Honor is aware, but under the emergency guardianship, it's 11-130-225. And it's a slightly different standard. We don't have to prove, because they continue to bring up the parenting functions under RCW 2609-064. Those aren't applicable. Those don't apply to the emergency guardianships. The only thing that applies is that emergency guardian is likely to prevent substantial harm to minors' health, safety, and welfare. That's one, that's A. And then B, no other person appears to have authority, ability, and the willingness. And it's our point at this time, my client has, there's no substantial harm. They're claiming, minor things with regards to Jaylyn that occurred a long time ago. Diapers and stuff. She's not in diapers anymore. My client was excluded for a long period of time because of a protection restraining order. There's a whole factual dispute back and forth. And if Your Honor is going to consider, going forward to today, we think it should be summarily that she just gets returned, that there's no emergency. If we're going to have a hearing today, the hearsay of the child is excluded. I got the statute for that. And then there's a lot of statements that are hearsay that if the court's going to consider the declarations, those type of things, there's hearsay. There's a lot of statements that where the party doesn't have knowledge of particular facts. It's, my client never did something with regards to Jaylyn. Well, where are the dates, times, places? What are we talking about? Did you observe it, or is this something that somebody told you? I mean, all those statements get excluded. So if we're going to have a hearing today, parties have to be under oath and state facts with regards to Jaylyn and my client. But he's the father and he has a constitutional right. I looked up Troxel because I hadn't read it in a long time since law school. It's got a great quote in that case. The liberty at issue in this case, the interest of the parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberties interests recognized by this court. It is cardinal with us that the custody, care, and nurturing of the child resides first in the parents, whose primary function and freedom, including preparation for obligations, the state can neither supply nor hinder. So your position is you can't supply or hinder my client's parenting. he needs Jalen, and then if the court wants to issue an order saying you can't have Jalen around Michelle's son, who has a criminal background, you issue that order, and if he violates it, then yeah, we're back in court on that. He's already told you what his plan is, that he's going to be living with his grandmother. Jalen will be living with the grandmother down in Toledo, Oregon. Got to keep those separate from Toledo, Washington. But he does that. She goes to daycare. She's in daycare now. He finds doctors for her. He can't do that because he doesn't have her. Or if he doesn't supply those, then potentially we come back to court. But at this particular time, with the dismissal of the emergency ex parte orders, Jalen should be returned summarily to my client. And if they want to go forward on a guardianship case, a different standard, in either one of them, they have to show clear, cogent, and convincing evidence. And the evidence is my client's a young father, and he's doing the best he can, and that's good enough for constitutional issues. So we're asking the court summarily on the procedural issue that there's no orders, return Jalen to my client, if we go forward, all hearsay and those type of issues and statements of the child are not considered, and that it's got to be relevant evidence that is not objectionable.
And I understand that. And here's again, kind of what I'm getting at here. So number one, I'm denying the motion to dismiss and return the child. I think that what has happened here is a procedural error on the court's part. I don't believe that deprives me of authority under RCW 11-130-225 to go ahead and hold what was originally scheduled as a show cause motion on the emergency guardian. That statute gives me broad authority to, on my own or on motion of someone else, to appoint an emergency guardian. So I believe I do retain that jurisdiction. I have retained that. And I do see, I think that's especially bolstered by the fact that there's the full or main guardian that's been filed and is set for trial. So I am going to deny the motion to dismiss and return summarily. We are going to move forward on the show cause for whether to put into place or not the order on emergency minor guardian. What I'm trying to be clear about, though, is that we're not going to spend 2 hours taking testimony on this. That is not what the statute contemplates on the emergency guardianship. So I want to hear from folks about what evidence or testimony you expect to put forward.
Yes, Your Honor. Again, this is a show cause hearing where only you're supposed to do it based on the record that's before you. And that is because of due process. The fact is that this is a quick hearing. Each party needs to be aware of what is going to be stated, which is why we don't need testimony here. The testimony is in the form of signed affidavits or declarations signed under penalty of perjury. That's the testimony. And I would argue, Your Honor, that I will be summarizing that testimony. Your Honor has read it. Your Honor can hear from Mr. Anagnostou and myself. No additional testimony is needed if we summarize the arguments, because no additional testimony is allowed. It is, again, due process. You get the testimony, you're allowed to respond, and then you have a brief reply. We've done that. I have a motion for an immediate restraining order on, which is really giving that, Your Honor, even more jurisdiction here, because that's what starts the process anyway of doing the emergency order. So I'd ask that just the attorneys argue and summarize. And even if we only have 5 minutes, Your Honor's read it, you've heard it. We have the same issues with regards to child hearsay. The fact is the guardian ad litem is given broad powers to investigate, to speak to the child, and to give the court information about the child conducted during their investigation, including what the child's wants, needs are, and what the child has disclosed to them. It is not for the truth of the statement. It's not put forward for that reason. It's put forward for a different reason. And that is just getting the child's view of what is going on. So the child hearsay, I'm not arguing. If I were arguing it as my client heard this, fair enough. But the fact is the guardian ad litem that is in the report, that report is allowed to go to trial in all these cases. The guardian's allowed to be questioned on that, and that's what we have here. It's essentially the same as a medical statement or a report of CPS, which are always allowed in these cases. So I don't know if Your Honor wants to hear argument, and I can start on why there should be an emergency order.
Yeah, and just a minute, and we'll get there in just a minute. Mr. Anagnosto, what evidence or testimony are you asking the court to rely on? It looks like you have witnesses here, and so I just want to make sure we're all on the same page about how we're proceeding on testimony. I do note the statute does contemplate that the court can make findings from affidavit or testimony, so I'm not opposed to some testimony being given live here today. I just want to be clear that this is not our trial, and I want to be cognizant of the attorney's times, the witnesses' times, but also the court time and this docket, which is not intended to be a trial docket.
Right, and that's what happened when we started hearing on this the first time, and that was, we were only hearing the emergency guardianship petition, I provided the court some of the transcripts from that testimony. You can go back and see the whole testimony. So I understand Your Honor is indicating that we can have limited testimony. But I want to, reiterate that the declarations that contain hearsay and the declarations that have no, factual basis for their statements are all objected to. And child hearsay is objected to, and if Your Honor wants the cite for that, that's RCW 9A 40.44.120, and it's clear. It's very clear that child hearsay is not to be considered in these cases. There's only very limited circumstances when it can be allowed.
Right, and I understand the objection. I am moving forward today on the hearing on the order for emergency minor guardianship. Are you anticipating oral argument to summarize the evidence that you would like this court to consider, or are you wanting to call your client or any other witnesses?
Well, I would call my client in rebuttal if we're going to hear testimony. He's here, he's prepared. We got witnesses that are prepared to testify on his behalf.
Right. I mean, and that's what I'm getting at. I'm not sure I'm getting a real clear answer.
I'm sorry.
No, I mean, technically, and certainly we could probably go till the noon hour, but technically this docket is over in 14 minutes. So, that's what I'm trying to get at is what are we anticipating timing wise? Are you anticipating calling your client or just reserving him for rebuttal based on what Ms. Winkles may say?
I would like to call my client. He has not had an opportunity to be heard. Ms. Winkles got through several of her witnesses when we ran out of time the first time.
Okay. Well, and that was a different scenario. And so I want the folks to be clear. I have not and don't plan to go back and listen to that because my understanding was it was a consolidated trial or fact finding on both the main petition and the emergency petition.
No, I don't think that's correct, Your Honor. It was only on the emergency.
We actually had a hearing on that, Your Honor. It's in the court minutes.
Yeah.
Dave Nelson said, I'm on the trial setting docket, so I can consolidate both of these together. You'll see that I had a trial setting notice as well, saved for that. And you'll see when the court scheduled the trial, they scheduled the trial for both of them. So that's not accurate. It was on both.
Yeah, I mean, that is my understanding. Let me just go back and make sure that is contained in the court minutes.
So this is what I recall happened. We started the emergency hearing and I requested pursuant to the court rules that it be evidentiary. We needed to have an evidentiary hearing on the emergency. And that's what we started. And then it ran long and got continued. After the hearing is when Commissioner Nelson said we should combine both of these for the next hearing. It was at a subsequent hearing that we had. I don't know if I had that.
Okay, so I am looking back at the notes from Commissioner Nelson on May 5th. It does look like you all discussed the proceedings, and Mr. Anagnostio's recitation appears most in line with what the actual notes state, that I think there was a discussion about doing it both for purposes of economy, but that the court stated specifically, quote, "We will move forward in re emergency minor guardianship." And then testimony began at 1:37, and you guys were still going until 5 p.m.
Your Honor, if you can look at the trial setting, the minutes from the trial setting, because I did a trial setting notice and we were heard on that and rescheduled. And then we started that as well. So we've started twice now.
Yeah, and then at the end of the May 5th hearing, the court set the matter for assignment on May 17 for a continued hearing. And then that's when one day continued trial to the week of June 19th.
Right.
And that's when there was a trial setting for the week of June 19th. And then trial was to begin on June 21st.
Right.
And then I think that's where things kind of then fell off the rails.
It fell off the rails at that point.
Yeah.
If you look at the, oh, it's not on the notes. Matter set for set trial. And that's on the court minutes from 5/17/2023. And that is at, yeah, it says court sets matter over. If you look at it, it's set to trial. It's not set to an evidentiary hearing. It's not set
right,
to.
I understand, but I'm looking at specifically what Commissioner Nelson ruled, which was whether he did this the right way or not, I'm not commenting on, but he did specifically state that you all were only taking testimony at that time for the emergency guardianship.
Yeah.
I'm not saying that's how we're proceeding in the future, because I want to be very clear. We're not going to spend 5 hours doing an emergency minor guardianship evidentiary hearing. That is not in the interest of justice. I don't think that's what the statute contemplates. And you all are set for an actual trial the week of August 28th on the full petition.
Okay, so that's what I wanted to make sure, because I have the trial setting notice on 5/8 and it says matter already set -RB. And that was my trial setting notice before any of that happened, to set for the full. If you'll look at it, it says it's the full minor guardianship petition. And so that's why I was confused. Maybe I was confused. I thought they were consolidated on that date. But so August 28th is for the full for sure. I just didn't want to have to set
Yes, so August 28th, although I just need to reach out to court admin to have them correct the year, because they put 2024. And I know that's not what it was set for. So we'll get that amended so that you all know it's August 28th, week of August 28th, 2023, 2-day non-jury trial on the main petition. But we need to kind of regroup about what we're doing with the order on emergency minor guardian. And here is my thought, because I don't think there's agreement on how we're going to proceed in this matter. But I want to be very clear that I think it is a limited evidentiary hearing based on declarations, and I will allow parties to testify. So I will allow Jaden to testify. Ms. Farr's testimony will be relevant to the court. I'm not at this time going to take testimony from, we have two folks on the line, I believe, for Jaden. Here's my thought, Mr. Anagnosto, if they have testimony they want the court to consider, I'm kind of going back on my idea that we do the hearing today. Here's what I'm thinking. That that we set this to next Tuesday's minor guardianship docket, that we set over the actual hearing on the order on emergency minor guardian for 1 week. That any of the witnesses other than the parties themselves and Ms. Farr submit declarations for me to consider if they have relevant information they want me to consider. And then I'm going to sign an immediate order extending through to next Tuesday at 10:30. I do think that that was the court's intent on May 5th when the evidentiary hearing was continued. They just didn't do it. So I believe I have jurisdiction to sign the immediate order through next Tuesday. And then I would ask the parties, I am going to limit testimony and argument to a 30-minute window, because that is what this docket contemplates. And I think that's what the statute contemplates. So if there is additional evidence that you don't believe could come out in oral testimony in that time frame, I want it to come to me through a declaration.
So my witnesses have already supplied declarations. So both Michelle and Teresa Ludwig. And so
that's the the ones that were filed on July 10th.
Yeah, those were filed. Yeah.
Okay.
So they've done declarations. My concern is this bumps along again and we don't get a resolution, and that's been
well, I mean,
contemplated by the statute.
Certainly I understand that, and I think that procedurally things haven't gone well throughout this case. In looking at the history of this was like clear as mud. So I get that. What I'm trying to do is get us back on the rails starting now. So I am going to, and believe I do have jurisdiction to sign this immediate order. I want to be very clear about what I expect the hearing on the order on emergency minor guardian to be next week, so that we don't spend a half an hour just discussing what the hearing is going to look like. So today, I believe I've set those expectations so that if parties believe that there's testimony on the order on emergency minor guardian, if they believe there's testimony that's going to take longer than 30 minutes, please supply it by declaration. I will take argument from counsel. I will take testimony, for instance, Mr. Anagnosto, if Jaden wants to testify. He is a party with, as you stated, very important and considerable constitutional rights to parent his child. So I'm not going to take away his right to testify live if that's what he chooses to do so. But again, I want to be very clear that I'm not, in looking back at the court minutes, this isn't going to be a situation where we're here until 5 o'clock taking testimony. Are all the parties available next Tuesday at 10:30?
If my clients can give a thumbs up, are you available? I know that this is getting really hard with their work schedules and that.
My client's work schedule too, so.
Well, and that's also why I mean, these dockets are meant to be expedited. So that's,
Jaden, can you give me the thumbs up or not, or next Tuesday? Okay, thank you.
the only concern, let's address one last issue before I sign the immediate order. My only concern is it does include the restraining order in its kind of an original full entirety. And I think that has been changed in this case, because we're talking about things like visitation. So I don't want to go backwards.
And it was, Your Honor, if Your Honor wants to just interlineate the visitation that was set last time, I believe he has daytime visitation.
Yeah, so what I'm going to do is go back to, I am going to sign the immediate order for emergency minor guardianship through next Tuesday at 10:30. But I am going to edit the restraining order sections so that it fully complies with our current visitation that Jaden is allowed with the minor. Okay, any questions about that?
The only question I have about next week, Your Honor, is if we're going to be limited to time, are we going to limit? I mean, I don't want Ms. Winkles to put her clients on and take up all the time and my client not be able to. So are we going to say they got 15 minutes and we got 15? I mean,
I think that's a great proposal. Let's adopt that as kind of the trial expectation or the fact-finding expectations. Certainly, if there's cross-examination, so one side is taking up a bunch of time from the other side, I will take that into account. It doesn't need to be, hard and fast rule, but I think if both of you plan for 15 minutes, I think that will be very helpful to the parties and the court. And I think that's a great idea.
Sounds good to me.
Okay. Ms. Farr, anything you think the court needs to consider further on this?
I think you covered it all.
Okay. Are you available next Tuesday? I failed to ask.
I'll make sure I am.
Okay, I appreciate it. And then Mr. Anagnosto, just so you know, since I think your ex parte motion for fees came into me because of all the submissions,
right.
I have put that in the ex parte box and let Judge Basher know that it's in there and they'll be reviewing that.
Okay. Yeah, when I sent this ex parte, I anticipated that it would come before you. That's why I had the return date or time would be later tonight. So I thought those were going to come to you, but.
Okay. Yeah, it created a little bit of confusion over here, but looking at the history of this case, that seems to fit with how this case has gone anyway. So just wanted you to know your other motion is in the ex parte box and should be handled today.
Okay.
Okay. All right. Thank you all. Jaden Ludwig. I believe Jaden is also online. Good morning to you folks. And then we have Ms. Winkles.
Hello.
Present, I believe.
Hello.
Ma'am, you are free to log off. Your case is done.
No, I've been trying to talk. I've been trying to talk to you guys.
Ma'am, I'm going to mute you.
I haven't been able to say anything.
Ma'am, your case is done. The parties are gone. I cannot hear further from you because they are all logged off.
I tried saying
Your
that I wanted to talk.
Case.
You guys wouldn't listen to me.
I have muted you again. We will remove you from the courtroom if you don't log off. You are to be back in court on August 8th at 10:30. Okay, we're going to continue with number 1. I see Kai Ludwig present. I see Kelly is present as well. And then Lisa Greenwald, is that a witness for one of the sides?
Yes, Your Honor. If we need it, as we stated before, we're each getting 15 minutes. I will probably just speak to those declarations that are already on file. But if you need the witnesses to ask any questions, you will also have them here. Their declarations have already been filed in this case as well.
Thank you. Okay, so let's go ahead and get started. Let me just pull up that digital file and I'm going to go through what I have reviewed. As all the parties know, we are here today on an evidentiary hearing on whether this court should or should not grant the emergency minor guardianship. The court's understanding is that the parties do have a trial date for the standard petition the week of August 28, 2023. The court has gone back and looked at the history dating back to the October 4, 2022 petition for emergency minor guardianship. Since that time, declarations have been filed in this case. I have reviewed those. I've reviewed the motions of the parties. I have reviewed the GAL reports and recommendations. I have taken into account, I want to state this on the record, when we were here last, the parties both were concerned about child hearsay contained in some of those declarations and reports. And I'm just going to state for the record that I do believe that child hearsay is excluded from my consideration in this case. So I will not be taking any statements of the child directly into account as substantive evidence. Certainly, I understand that the GAL may base her recommendations in part on an interview with that child, so they can come in as a foundational basis for different witnesses' opinions, but it won't come in as substantive evidence in this case. So that is my ruling on the child hearsay. Any preliminary matters either attorney wants to take up?
I just have a quick question.
ahead.
Also, just so you're aware, my internet is not working. I had to log out, log back in, so we
Okay.
get video or voice, but not both apparently. My question is, if I save 2 minutes for cross-examination, if I believe Mr. Anagnostou is going to provide live testimony, I would like the chance to cross just for 2 minutes if I save that out of my 15.
Okay. Mr. Anagnostou, do you anticipate calling live witnesses?
I do, Your Honor.
Okay. So we'll, Ms. Winkles, you can go ahead and reserve that time.
Okay, thank you, Your Honor.
Okay.
And then as a preliminary matter, in addition to the child hearsay, I also object to the declarations that are made without foundation, i.e., day, time, place, who was present, witnesses. Most of the statements are just kind of blanket statements that my client, wasn't or was doing something, and day, time, place, those type of foundational issues were not submitted. So I did object to those as well, Your Honor.
And those, I did look, and I'll just say, I think I can answer this one, Ms. Winkles. I did look at the declarations in depth. I think those types of objections will go to the weight that I would give that type of evidence, not necessarily the admission of those things. So if we were in front of a jury, maybe excludable, I feel very confident that I am able to parse through the weight that I would give those types of statements. So let's go ahead and get started. Ms. Winkles.
Yes, Your Honor. Let me just get to the time. Okay, so I'm going to time myself so that I know where I'm at. Yes, Your Honor. My clients are asking for the emergency minor guardianship to be granted. In this case, if you look at the RCW for the emergency minor guardianship, it's not just who has the authority. It's also who has the ability and willingness to act to protect the health and safety of the child. In this case, the father does not have the ability. And this can be shown from historical evidence. The first is that when he had the child, for the first 18 months of the child's life, the child did not see a doctor. The child was essentially deaf. She suffered a significant developmental delay because of this. She could not speak at all at 18 months. Mr. Ludwig did nothing. He didn't take the child to the doctor.
it would have been quite obvious that the child was deaf. Yet Mr. Ludwig did nothing except for smoke marijuana, didn't have a job, and took no interest in his child. Instead, it was my clients who eventually, when they got the child, they took the child to the doctor. The child required surgery. The child required significant educational interaction and significant additional intervention in order to reach her developmental milestones. The only reason that child is on level today is because of my clients. Father did nothing. Father took absolutely no interest, which is a theme you're going to hear in this case a lot. Father takes no interest. The people around him are who take the interest. Father's been repeatedly kicked out of different homes throughout his life. He's already been kicked out of his grandmother's home, the home he claims that he's going to live with his child. He already lived with his child there and was kicked out. It's not a home that is sufficient for this. It is a 2-bedroom, and dad or child would have to sleep on the couch. There is not enough room for them, but dad doesn't live there anyway. Dad has never lived there since the last time he got kicked out. Who does dad live with? Dad lives with his girlfriend and her son, who is a registered sex offender for a minor child. Now, dad thinks it's okay to continue living with his girlfriend. Dad claims that he's going to move in with grandma. The problem is that grandma and girlfriend's house are significant distance. They're hours away from each other. Dad's job is near girlfriend. And we'll provide testimony on cross-examination. You'll hear that on June 18th, dad actually took child to sex offender's house. And we'll be able to elicit that. Additionally, dad knew he couldn't do this. Dad knew he didn't have the ability and he didn't want to do it. And why do I say that? Even though it wasn't legally binding, he gave up custody in the intent of giving up custody to my clients. Then he assaulted my client. There was a police report, and all of that's been filed. Now, dad claims that he was not convicted, and so it doesn't count. You'll see the testimony in there by Holly Ludwig that viewed the actual event, and even grandma, in this case, who's now for dad, also wrote a declaration at that time to the police officers. This is a man who cannot control himself. He can't control himself. He's yelled at Commissioner Nelson when he was in the court earlier. And this is a man who has no ability to parent. He's done absolutely nothing. He knew he did not have ability when he gave the child up then. He still doesn't have ability. He's done nothing but an online parenting course. That doesn't change one. There has to be some significant change and significant want to change. Classes, be it any counseling, any of these things to get dad to go from A to B. Dad's done none of those. He wants you to believe that he is fully formed de novo from the earth and suddenly knows how to parent. That's not the case. Dad consistently makes bad decisions which put this child's health, safety, and welfare into significant and substantial danger. And I mean that by the fact that dad continually takes this child to his girlfriend's house. And we're going to provide testimony. We're going to have dad provide his own testimony about June 18th. And we're going to show records of impeachment if dad goes against that, showing that he had the child that day. He left the area and he went and took this child to his girlfriend's house where a registered sex offender lives. This is not a good choice. This puts the child at significant and substantial risk of harm, as does not taking the child to the doctor. Dad has still never taken the child to the doctor. Only my clients have. Now, dad's going to say that he's never abandoned this child. That's frankly not the case. When dad gave up custody, he was only supposed to do it for a period of 6 months. But dad didn't call child. Dad did nothing. They're going to claim that there was a protection order in place. Well, there was against Mr. Ludwig for Kelly only. And they made that very clear that only Kelly. It wasn't against the house, and it wasn't against the child, and it wasn't against grandpa. In fact, you'll see from the testimony of grandpa in the declarations, grandpa, my client, Kyle Ludwig, tried to get his son to go visit the child, and he was ghosted. It was essentially crickets. Then suddenly, out of the blue, dad shows up demanding the child. But it's not just dad. Who is it? It's grandma and his girlfriend in tow. Again, you're going to hear that dad doesn't do anything. Dad smokes a significant amount of marijuana. Dad has never held a consistent job. The women around him are the people that actually take this child and the responsibility of that. That includes changing the child's diaper, feeding the child, any of the parenting functions. Dad is always delegated to those around him. And in fact, you'll see from the declarations that were submitted by Lisa Greenwald, by Miss Melody Boone. The dad sometimes doesn't even know where the child is. He's inside smoking weed and playing video games while somebody else is caring for the child. Dad has a history of flying off the handle. He's not safe to have this child alone. And what I mean by that is you'll see that in the declaration that he has a DV petition against him in Lincoln County, aside from the assault of Kelly Craig. The fact is that dad wants the court to give him this child because he says, I am dad. But the emergency minor guardianship is clear. If a parent does not have the ability to protect the child from substantial harm of the health, safety, and welfare, then we look at these minor guardianships. The fact is dad taking that child to a registered sex offender's house, that alone is enough. But on top of that, you'll see a list of all the times dad has been late or not shown up for visitation. If this is really a man that has the ability to protect this child from substantial harm, why is he never there on time? Why is the child wet? Why is the child not fed? Why is the child not put down for a nap? This is especially true when the court ordered it. Now, dad's going to say, well, just make an order that I can't take the child out of the area. Well, if we could make an order that dad would follow, that would be great. But that hasn't happened yet. Dad is repeatedly not there because of any number of reasons. But the biggest one is dad consistently violates these orders. Dad cannot take care of himself. You'll read in the testimony, the declarations provided, that dad doesn't bathe. The dad has problems keeping jobs. He's gone through a lot of jobs. He has a job right now, apparently, but he hasn't had this job very long, and they come and they go. He has never paid rent. He has never supported himself. The idea that he could provide and protect this child against substantial harm, it's ridiculous. He can't even protect himself. He lives off of the benefit and regress of other people, and they eventually get sick of him and kick him out. Everywhere he's been kicked out. The fact is, dad has never given any type of indication of where he's actually living. He says he's, quote unquote, going to live with his grandmother, but he's not there yet. Where he is with a registered sex offender. This is not, dad may think this is fine, but it's not fine. And you'll see from the declaration of his girlfriend that her interest, her care, her protection is on her son. You'll see that from her declaration that states, how dare you say that she's come here and get my child thrown in jail? The concern is that if this child is sexually abused while at dad's real house, that nobody would protect this child because they'd be looking to protect this son, this felon that's already a felon. The fact is dad smokes, as I said, a significant amount of marijuana. He is not in control of himself. When he gets money, you'll see the testimony, when he gets EBT and food stamps, he buys junk. He has never supported this child, at all. My clients would like to see, before there is any sort of expanded visitation, and really, again, we've been through this for months. The fact is that we've had multiple hearings, and at each hearing, dad demands more visitation, and at each hearing, he's denied. And the reason he's denied is because this is a man that has a history of domestic violence in Lincoln County. He was also accused of assault. You'll see the pictures where he beat my client. He has had no substance abuse evaluation with collateral contact, yet this is a man that is perma-stoned essentially and smokes weed in the morning until night. This is a man who shows no proof of where he's actually living and who he's living with. He needs to show proof that he's living in a place without a registered sex offender, felon, or person with a drug history. He's never taken anything other than an online parenting class, and we're not sure that he even took that.
Yes, Your Honor, and that matter's ready. My argument is brief. It's just a presentation. I wrote down what Your Honor said, so whatever Your Honor wants to do is fine with me.
Okay, and I'll just let the parties know, I did receive the proposed order from Ms. Winkle's office. And then I did also receive and have a chance to review the objection to the proposed orders, specifically paragraphs 3 and 14. I have gone through it. it and compared it to my ruling at the time of the hearing. Let's start with paragraph 3. Mr. Anagnosio, do you want to be heard on any oral argument on it? Otherwise, I'll just go through my notes based on my review of your objections.
Well, yeah, it's pretty self-explanatory. I lined out the provisions, but I didn't think the court made a statement that my client's own declaration. I don't recall that at all. Even bringing that up showed lack of self-awareness. But it concludes with he's not willing to do evaluations. That's just wrong. I mean, my client has said repeatedly he'll do whatever evaluations they want to pay for. He has repeatedly said that. He's open for that. He did it. He said that in his declaration. So I'm not sure how that ended up or why it would end up as a finding by the court. We did have the conversation Your Honor mentioned about injury after the fact, and I understand you made those statements. I think my client's being convicted on a pretext and not given an opportunity, but I understand you did say that. So I didn't strike out that the statement made in this case, if someone were to happen, would go back to jail, is after the fact. I think you did say that. And then I struck out the next sentence after that, that there wasn't a finding that the child would be exposed to Michelle Harrington. His evidence has been that he has not. If you recall, they tried to use some Google search things to say that he had went to Oregon, and it just fell flat on his face when it was proven that he had gone to Silver Lake, Washington, not Silverton, Oregon. And that's where, the other parties live. But so I don't believe you made any of those findings that I struck out on 13 or on 3, and would ask Your Honor to strike those out. And then on 14, the dinner issue we discussed, and there's occasions where the petitioners want to feed Jalen dinner on Sunday, so my client allows that to happen, but this says he has to feed her regardless. And I mean, if that's the court's ruling, I just don't believe we had a conversation about that. And that I believe you did say the parties are to communicate regarding text if my client's going to be late, so that there's some kind of communication about when they would be picking up. And we did set the pickup place at the Papa's Pizza in Castle Rock, so I didn't strike that out.
Okay.
Those are my objections.
Thank you. Ms. Winkles, anything you want to share?
Yes, Your Honor. The thing about the food was because Your Honor stated that you were going to keep the parenting plan how it was. That was in the older parenting plan. Your Honor absolutely did mention that the declaration showed a lack of awareness. I copied word for word. I believe it was late. The problem is if Your Honor had said it. So I would just go with whatever Your Honor states.
So I did have a chance to look back both at my ruling and the declaration. So let's just start at paragraph 3. There are some things in the proposed order that I'm going to modify a bit. So let's start at where Mr. Anagnosio started the strike and the court further takes into account. Do you all see that?
Yep.
Okay.
Yes.
So I do that was part of my ruling up through such as mental health evaluations and DV evaluations. So I'm going to leave that sentence in, and I'll tell you, when I made that ruling, I was specifically relying on pages 5 and 6 of his July 8th declaration, where he tells the court that he has done nothing to warrant the necessity of this demand, that it's offensive and belittling. That's as far as a mental health evaluation. And then the DV evaluation, he says again, why and who's going to pay for it. Same thing with substance abuse evaluation. So I do recall in my ruling that I reviewed that declaration and did take into account what I believe to be his unwillingness to do those things. The next sentence, the court finds there to be objective evidence that there has been DV incidents and or physical confrontations. I'm going to strike. That was not part of my ruling. I am going to, on the next sentence that Mr. Anagnosio objected to, I'm going to change it slightly. It is going to say the role of this court is to prevent harm to the child, comma. What did I write here? I have to read my own writing now. Not simply, add the word simply, not simply to address it after it has happened. I'm making that change because I do think the role of the court is both to address the harm after the fact, but also to prevent it. So I'm just making clear my ruling on that. And then let's go down to the rest of the strike regarding the court finds that the substantial weight of evidence leans in favor of the court preventing that. I'm keeping that sentence in. The rest of the objection regarding my findings regarding the financial support with Michelle Harrington, that is pretty close to verbatim exactly what I ruled. I did find that that led me to believe there would be reliance upon Ms. Harrington and therefore a likelihood of harm to the child should the child be with near Ms. Harrington or her son. The only thing I'm going to change is page 3, the very last part of the last sentence where it says right now, the court believes that this, I can't read that word. Oh, this alone is a standalone basis to grant the emergency petition. I think that goes a little far from my ruling. What my ruling was is that the court believes that this is a further basis to grant the emergency petition until the date of the hearing. I will be perfectly honest with the parties. And again, we all know I'm coming into this midstream. I don't recall specifically ruling that I expected the father to feed the children dinner. I went back and looked at Commissioner Nelson's prior rulings. I'm not saying it's not there, but I don't recall making that ruling. So my preference would be to strike it, but keep in part of the visit will be between just the father and child. Because I do think that that's accurately what we discussed. Do the parties want to be heard on the dinner issue? I'm just not finding support in the record for that.
No, Your Honor, it was on the last order or the order before the last order. It was like an ex parte order. I have no issues with it going away.
Okay. And then I do also think I will strike the father has a window to collect the child 9:30 to 10. We specifically took that out, I think, at one of our prior hearings and instead added the parties are to communicate via text if there will be a delay. And we did that when we made the change to Papa Pete's. So any questions about those changes?
That's the only one that I have a concern with.
Okay.
My clients have other children as well, and it's their weekend and their only day off. Dad sometimes is more than an hour to too late. That means their entire day is gone if they've got a birthday party, and they're also waiting with a little 3-year-old child in a car for an hour.
Yeah.
And so that's the concern.
And I remember we talked about that. Do the parties know, has it been an issue? Because I think we made that change about a month ago. Has it been an issue where he's still showing up, up to an hour late?
I don't know that it's an issue. I mean, we haven't gotten any messages from council saying that it's been an issue.
Yeah. Ms. Winkles, I'm inclined to strike it because I do know that is something I did take out about a month ago in favor of the switch in the location. And so I do think we're going to go ahead and keep the parties are to communicate. What I'll say, if this becomes an issue, please renote it on this docket and we can revisit the issue. My hope is that it isn't going to become an issue, but I certainly can't guarantee it. But I don't want to change my ruling without the parties here to, talk about it.
Okay.
So that'll be my ruling on that order. Since it's do we have the original? Ms. Winkles, are you able to make those small changes, or do you want me to interlineate those? I'm happy to do either.
I can make those small changes, or if it's easier on your honor, if you've already got a copy there, it's up to your honor what you want to do.
I think these are pretty minor changes. So why don't I just take care of it after docket and I'll get it signed, and then.
Sounds good.
And you all know that the order is signed. Okay.
Thank you. Yep. Thank you, Your Honor.
Mr. Anagnosto, anything else on this matter?
No, Your Honor, that was my.
Okay. And then I know you all are still set for trial, I believe, so I don't think.
Right.
And this order extends through the hearing on that full petition. So do the parties want a review date on this docket, or what is your preference?
I think the trial's coming up so soon. I guess we can note it if we want one. Otherwise, I would just say just for the trial, because we'll have trial readiness as well.
And my concern is if trial doesn't happen, which has happened a couple of times with this case.
Right.
So.
Do you want me to set a 30-day review and then we can strike it, certainly if this has gone to trial and we don't need it?
I would prefer that, Your Honor.
Okay, let's do that. Let's set this on just as a review hearing. Mr. Anagnosto, would September 26th work for you?
Yes, Your Honor.
Okay, we'll set this just for a review September 26th.
You can watch more of this story in part 3, where we'll cover the morning of day 1 of the trial and hear testimony from Dad's stepmom, the current guardian.